2, 1. One, two, 1, 2. 1, 2, 1, 2. 1, 2, 1, 2. One two one two one two one two. One two one two one two one two. One two one two one two. One two one two. Yeah. 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 One two one two one two one two. One two one. Yeah, get your thing. Over that touch. One two one two one two one two. One two one two one two one two. We are about to resume. One two one two one two one two. One two one two.
One. One, two, one, two. Good morning, all. I just want to make a quick announcement, or actually it's a reminder of the protocols in place for this auditorium. Importantly, number one, there is a red line on both sides of the auditorium in the aisles. No member of the public or the media is allowed to cross that red line. Secondly, members of the public, you are to confine yourselves to the public gallery. The benches in between that aisle up there, just below the public gallery, and the front here is reserved for media and legal representatives, the legal teams. So please respect that. Members of the public, please do not come down into the media and legal area. And yeah, we will be starting shortly. Please make sure that your cell phones are off or they are on silent. If you need to work, put them on silent. Make sure that they don't ring and disturb the proceedings in the process. All right, it is 29 minutes past 9. We are about to start. Please stand. Thank you.
Longer than usual, Mr. Michaels. Good morning, Ms. Silog. Good morning, Ms. Hassim. Good morning. Please place your name on record. My apologies. But good morning, so long.
Good morning, Chair. I'm Advocate Missy on behalf of Mr. Madlanga.
Sorry?
I'm Advocate Missy on behalf of Mr. Madlanga.
How do you spell the surname?
Missy, M-I-S-S-I.
Oh. And good morning to you too, Mr. Madlanga.
Good morning, Chairperson.
Thank you. Who do I look to or at?
Well, address the Commissioner's Chair. As scheduled, we continue today with the testimony of Mr. Matala. The Chair will recall at his last appearance, his legal representatives intended to move an application in terms of which they sought to assert certain of his constitutional rights. It was agreed that that application will be in writing. That application and its argument will be dealt with by Ms. Hassim, and at the conclusion of which I will then proceed with the testimony of Mr. Matala. Thank you, Chair.
Thank you.
Thank you, Chair.
Yes, Ms. Hassim.
Chair, we are here to start the morning's proceedings at the behest of the legal representatives for Mr. Matala on the basis of an application that they brought on the 21st of August. As the Chair and the Commissioners will recall, there was a very strict time frame that was issued for the delivery of pleadings in that application.
Was it in this matter that for the first time I even said there should be no slippages, or was it in another matter?
It was in this very application, Chair,
Yes.
in which you emphasized that there will be no slippage, and you were precise about the time at which the various pleadings and heads of argument ought to be filed. So we have, as the evidence leaders, there was an affidavit filed, not on time, on Saturday. It was 45 minutes late. The evidence leaders responded to that by means of an answering affidavit that was filed according to the schedule.
Was there an explanation, even if informal in the sense of a letter as opposed to perhaps an application for condonation? I've not seen an application for condonation, but at least an informal explanation, say by letter, for example,
Chair,
for their lateness, for Mr. Matlala's lateness.
What I'm advised is that there was a delay in obtaining the signature from Mr. Matlala. We then requested the unsigned version. So what was 45 minutes late was the unsigned version. We don't know why that could not have been provided on time, because it was the unsigned version, with the later to follow. The later signed version came much later in the day. We don't have any further explanation for it, and my learned friend will no doubt have to address the Chair on that. But just to put the order of events in context, this is in the context of the ruling. The evidence leaders then filed the answering affidavit, which was due at 10 o'clock on Saturday morning. That was duly filed. The second aspect that we were required to address was heads of argument based on the application. Those heads were due at 6 p.m. on Saturday. They were duly filed at 6 p.m. on Saturday. What we did not receive by the evidence leaders, what we did not receive was the replying affidavit from the representatives for Mr. Madlanga, which was also due at 6 p.m. on Saturday, nor did we receive heads of argument. We've not got an explanation other than a letter, and Chair, if I may take you to that letter. I'm not sure if it's in your correspondence bundle or if it is provided to you separately. It's a letter that was provided on Saturday at 5:05 p.m.
But if it's the letter that, amongst others, says Ms. van den Heever could not attend the consultation, she was not well, and also talking about the replying affidavit and written submissions which were not filed, we have had sight of it.
That's the letter I'm referring to.
Yes.
What we understood from that was that there was still a consultation to take place with their client, and that we would receive the replying affidavit or the heads at some point on Sunday. It never arrived. I must also say that the heads of argument, of course, are not dependent on the consultation with the client. The heads of argument could have been provided. As we sit here, we do not know what the legal basis is for this application, other than broad assertions of the privilege against self-incrimination and what we've seen from the affidavit, that they wish to rely on a challenge that they intend to bring in the pending trial in relation to the chats and the recordings as being unconstitutionally obtained evidence. I'm not going to stray into the merits of our opposition to the application at this point, Chair, because I'm jumping the gun. My learned friend must address you first. All I want to do to begin with is to place in context how we are sitting here before you today, which is we have filed our answering affidavit and heads of argument. We've received nothing from my learned friend. And we've not received a condemnation application or a postponement application.
All right, all right.
And I think once my learned friend addresses you on the merits, I can then turn to the merits.
Thank you, Ms. Hassim. Ms. Missy, let me start by correcting myself before you address us. I gave instructions very early this morning that a directive be sent out that in the event that a postponement is not granted, I direct that only 30 minutes of argument will be allocated. I referred to a postponement because of an erroneous recollection of the contents of the letter that Ms. Hassim has just referred to. My memory, which was a lapse, was of the view that that same letter also sought a postponement. My co-commissioners this morning corrected me and said the letter does not seek a postponement. So I thought I should, in case my directive created confusion, just correct myself up front. But I must say this, if we get to the point where the application has to be argued, my directive as to time allocation stands. Let's hear you.
Thank you, Chair. I've considered how I would address the Commission with regards to this, and I deem it important to refer to a folktale that I've often heard in the corporate world. And the story goes that a security guard was once informed that the boss or the CEO of the company has given instructions that before 6 a.m., no one ought to enter the building. And the said CEO, on another day, attempts to enter the building before 6 a.m. And what he's told by the security guard is that, boss, umthetha uvumi. You will not enter here. I was told that you do not enter before 6. It does not matter whether you are the CEO or you are the one that gave the rule. I will not open for you. And I proceed with that because I want the commission to get a proper understanding upon which the entire team of Mr. Matlala labors under. Correct. One would note, as correctly put before the commission by Ms. Adila Hasim, that we did endeavor to provide them with an unsigned affidavit 45 minutes late. That's correct. It then took us approximately 3 hours to file our subsequent signed affidavit. Logically, as an individual, a layperson sitting anywhere would wonder to themselves, but if you had an unsigned affidavit and you only needed for your client to consult, make whatever changes you needed to make, why would it possibly take you 3 hours for you to then get a signed affidavit that's commissioned and file it and serve it on the evidence leaders? And that should give you a picture of how difficult it is for you to get access onto the premises, to get driven from your entrance as a visitor all the way into CMEX. When you enter the entrance at CMEX, how long you have to wait to get searched to complete the forms for you to then get taken from that point and walk into CMEX, where you also at that point have to wait for somebody to come and take you up to the boardroom that we have fortunately been allocated by management within CMEX. You then are in there, you're not allowed to have your cell phone devices, which in this day and age, that's what we primarily depend on to get access to the internet. With that being said, we would then have to go through the affidavit. You go through the affidavit, you make the changes. You now have to call said individual to come back and to take you guys downstairs for somebody to open the door for you to get out. You are not allowed, and I actually have got a tongue lashing personally by the management of security at CMEX, informing me that I do not understand and cannot comprehend the level of security and risk that I'm putting myself under by wanting to roam around the CMEX prison without somebody there to guard me and to accompany me. I then was taken to another office where I had to wait for somebody to come and take me to walk out and go to the security with my learned friend, my instructing attorney rather. We then waited approximately 30 minutes to get a ride from CMEX all the way to the gate. We would be able to get access to our phones, get the internet, and for us to then, I apologize for that, and for him to then go and print the affidavit and then come back. That is a process on its own. We then have to start again, request for us to get a pickup to go back to CMEX, follow the whole process, somebody to pick us up as I had explained initially. And that on its own tells you the difficulty under which we have to labor to get an act that would ordinarily take plus minus 35 minutes to get done. But it took us almost double the time. Over and above that, we did indicate to the evidence leaders that we had an issue because our lead counsel, Ms. Van Hever, was the one who was scheduled to go and consult with Mr. Matlala. So on the way there, when they had received the replying affidavit, she was unable to consult. She turned back home. And by the time we were able to speak to her, I couldn't go back in. I'm then further instructed by I'm told by my instructing attorney that even when he arrived, he was not allowed to go and consult where we were allocated to consult previously. He was treated as an ordinary visitor. So all he could do was hand over to Mr. Matlala the answering affidavit rather, and explain to him his understanding of the legal issues and the position that we would take going forward. Mr. Matlala then gave him instructions that he would need to read the replying affidavit and he wants to consider the limited advice that he has received from the instructing attorney, and that he also wants to hear the position that is being taken by us as counsel. And again, you note, we don't have cell phone devices. He does not have access, rather, to a computer where we could possibly send him an email and maybe in the evening he could quickly just see what it is that we've said, and maybe then, before we arrive, he would have a position and we could proceed. On Sunday, Ms. Van Hever then gives me instructions to go with our instructing attorney to attend to this consultation with Mr. Matlala. I personally attended to it. I had to grovel with the head of security and beg for him to at least give us 5 minutes to engage with Mr. Matlala so that we would be able to at least give him an idea where we stand, and then hopefully we can get some instructions. Over and above that, while we were at the prison, we then receive another affidavit from the evidence leaders, which they intend on using. That same affidavit I had to quickly give to Mr. Matlala to glanced through. He didn't even get an opportunity to read it and to give us a position, and we do believe that he has to address it in the replying affidavits at minimum.
Is that other affidavit the one deposed to by the senior investigator, Mr. Dlamini?
That's correct, Chair. That's correct. And so with that being said, the limited time that we had while trying to balance getting information from Mr. Matlala and maintain relationships with the individuals that tomorrow we have to come back again and beg on a Sunday if necessary to give us access to him. We then had to respect the time that they'd given us, quickly give him what we gave him, have him glance through the affidavit, at which myself, personally, I had not read through, and I couldn't even give him an idea of exactly what is being said in the affidavit, except to say it was from the lead investigator and it has to do with a consultation that they heard on an earlier encounter with the evidence leaders, I believe. With that being said, we were unable to get instructions from him. The little information that we got required us to then create a strategy of how we'll move forward and still be efficient. And our conclusion was that the best way to move forward would be for the instructing attorney to go through the docket again, go through the Section 204 affidavit so that he can adequately provide evidence before, rather depose to an affidavit that is correct and properly represents Mr. Matlala. We have not been able to conclude that process, and as a result, we were unable to file our replying affidavit as we had intended to on Sunday, Chair. With that being said, from Saturday, Ms. Van der Heever has been sick. And I do believe in her first appearance on behalf of Mr. Matlala, at some point she intimated that she suffers from rheumatoid arthritis. That has put her in a position where she's so ill. I was engaging with her this morning. She can't use her hands or feet. She's with the doctor and they're consulting to see a way forward. But what she did guarantee me is that hopefully with the medication that she's receiving, by the afternoon, she'll be in a proper position where she'll be able to continue with us working and appear tomorrow to argue. So my instructions right now, having considered the fact that we are constantly being hit with umthetho awuvumi, you cannot do this or that, and we have to try and navigate the systems where ordinarily a layperson not sitting in this commission would think, well, these individuals are incompetent, or maybe perhaps they're trying to not come before this commission in good faith. That is not the position. You have to be in it to truly understand what it takes for you to properly represent Mr. Matlala, because he is not an ordinary witness that you have access to at 12 a.m. rather in the morning, or at 3 a.m. in the morning. We don't have that liberty before us. And I do know with regards to the additional bundles that we receive later on, they make it even harder because he wants to read. He wants to know what's being said there so that he can give us proper instructions moving forward. He's not in a position where he feels comfortable that it would be smart and wise for him, given the status that he holds outside of the commission, to say to the commission, well, I did say let's go ahead, without considering the implications that it would have on him. And we beg this commission, humbly so, Chair, to consider all the elements that we consistently have to deal with to try and ensure that we represent Mr. Matlala, and also stand before the commission in good faith, that we're given an opportunity to file that replying affidavit, our heads of argument, and as well as a written condemnation application for the late filing. Thank you, Chair.
Thank you, Ms. Missy. Yes.
Chair, just 3 points.
May I just raise an issue, Ms. Missy? What the evidence leaders answering affidavit raises is a legal question, or rather what it raises are legal questions, 100%. So I don't understand this issue of agonizing over how, when to consult Mr. Matlala with regard to a replying affidavit. Those are legal questions which would not necessarily have required Mr. Matlala. Those are legal questions that you, as lawyers, should have been able to respond to. Truth be told, actually, there wasn't even a need for a replying affidavit. You could just have put together written submissions, and you would not have been out of time. So I have difficulties understanding the difficulties that you say you had.
Chair, yes, to the effect that it relates to legal issues. But there's also information during their consultation, as limited as it was, where it became clear to us, having had sight of the replying affidavit, that there's factual elements that need to be addressed that relates to documentation which we did not, or rather they did not have at hand when they were consulting. To say to that, we received a further document this morning from Mr. Madlanga that he was unable to go and obtain from his, the room or the prison cell that he's been kept in. And it speaks directly to the issues that would have to address in terms of the legal points. So there's a factual element
That's
to it
very
as well.
peripheral. Those issues about whether Mr. Madlanga received certain documents a day or two before the hearing of his testimony, those are very peripheral issues, and they have nothing to do with the legal questions that Mr. Matla's application raises. So I think my point stands.
Chair, I did not hear the last few words that you said.
I said I think my point stands.
Noted, Chair. Noted.
You are free to respond. I'm not a dictator.
No, Chair, I believe what I've set down in terms of the entire process and how we found ourselves here today I can't explain it any further than what I already have, Chair. And as I stated earlier on, I can only beg this commission to take into consideration and to give us a chance up until
I'm
tomorrow
listening. You
morning,
may
Chair.
continue.
Thank you, Chair.
Let me indicate what my inclination is, which you would obviously have seen in the directive that I issued. In fact, I sent it out to the attorneys after 6 a.m. I don't know what time they instructing them to write a letter to Mr. Matlala's attorneys. I don't know what time that email was sent, but I gave the instruction after 6 a.m. My inclination is for Mr. Matlala's application to be argued now, this morning. That's my inclination. What's your response to that?
Chair, my application for a standout tomorrow, still, that is the position that we're taking. If the chairperson could grant us that opportunity to come before this commission prepared, and at least for you to have sight on paper, at minimum, some of the case laws, because we do believe that this is an issue that has never been dealt with by any commission in South Africa. Speaking to the position that we find Mr. Matlala in, and we do deem it imperative that you have sides, yes, of the legal argument, but also the case law that we rely on to make out this argument. I don't know how efficient it will be, given that it's a constitutional issue and the position that we find ourselves in, and we've tried to look and research to see internationally if we could find something that could give us guidance on this here, on the issue that we intend on arguing. And we do believe that it would be of a benefit to the Commission to have sight of the case law and our written submissions, Chair. I don't know how beneficial it would be if I only argue this and you are unable to make reference to those cases and the paragraphs and see exactly, is she applying herself correctly? Do you agree with me, yes or no, and what's the position? And I think perhaps that's the consideration you'd have to make in finality, which is one, this is a position that we believe any commission here in South Africa has never had to deal with and answer and consider, and perhaps it would be beneficial to have consideration of the cases that we would like to refer to or refer the Commission to, Chair. Thank you.
Thank you. I will go back to the question that I asked about this being a legal question. This is something that Ms. Vandenheefer was quite passionate about from the day of the last appearance. She referred a number of times to an application where points in limine would be raised. From the moment that you start thinking about bringing an application in which you are going to raise points in limine, you already know what the law that supports you is. So it should have been a matter of relative ease. In fact, even easier for you, Ms. Vandenheefer, as Mr. Matlala's lawyers, to argue the law than it would be for the evidence leaders on whom you are springing these points in limine. So I'm not sure that I follow your response. Can you tell me why written submissions were not or could not be filed on legal issues that were the start of all this, legal issues that you thought of even before commencing this, the process that we have before us this morning? And underlined, you were ready with the law right from the beginning. Otherwise, you would not have even considered bringing an application in which points in limine were being raised.
Chair, I can only take you back to the fact that from our consideration was that it was imperative for us to prepare the replying affidavit. My apologies. From our considerations, we found it or deemed it imperative for us to prepare the replying affidavit and to get further instructions from Mr. Matlala with regards to the position that we're taking. And I do note the point that you're making that perhaps what we could have done in the interim was prepare the heads of arguments to assist the commission and have them filed on time. I take note of that, Chair. But that was a delay that came as a result of the consultation, the considerations that we had to make, which is that given the answering affidavit, we deem it important to get further instructions from client with regards to the replying affidavit before we proceed with penning down the position that we've taken with regards to the application. That's as far as I can take it, Chair.
Morning, Ms. Missy. The point is simply this. Mr. Matlala would not have assisted with the law because the law is for lawyers to research and to argue. He could only have assisted with the facts and the giving of instructions as far as whether he wants to persist his application. But the law is for the lawyers, and the moment they advised him to bring this application, this was the time to start considering, especially being aware of the strict timelines under which this commission operates. We simply cannot afford a wasted day because our schedule is already very tight, and that is the difficulty we find ourselves in.
Commissioner, it goes back to the considerations that we made. If I have to make further submissions, then I have to make up stories, and I'm not prepared to do so. What I have explained to the Commission is the step-by-step process that we've gone through, and I do take note of the points that both yourself and Chairperson are raising. Thank you.
Yes, Ms. Hassim. Perhaps let me just ask this quick question of Ms. Sillo. How much longer do you think Mr. Matlala's testimony will take? I know those estimates have regularly been overshot.
I know, Chair, and in this case, it shall be particularly so because Mr. Matlala's testimony in truth hasn't even begun. So all he's done is read his statement into the record, which he has sort of supplemented through this application. I guess he may want to place that also on record. We had anticipated a minimum of 2 days after he has placed his statements on record, Chair.
So today and tomorrow?
Today and tomorrow. A minimum of 2 days. Thank you, Chair.
All right, thank you, Ms. Sillo. Yes, Ms. Hassim.
Chair, just a few responses to what Ms. Nisi has submitted. The first is, and just to correct some of the facts. The first point relates to the filing of the founding affidavit. It was due at 10 a.m. on Friday. This was subsequent to the directive of the chair that was made on Monday. So there was a long period between Monday and Friday for the purposes of consultation with their client before the filing of the first affidavit. So the long explanation that was given about the difficulties with accessing the client in correctional services doesn't really assist in relation to the founding affidavit because there was sufficient time. But it's not only sufficient time from the period between Monday and Friday last week. Mr. Matlala's legal representatives have been raising this issue for some time, prior even to Monday. They are aware of the categories of evidence that the evidence leaders wish to canvass with him in questioning. They've known this since at least March of this year. So this application could have been brought much sooner. And so all of the time, in fact, that was available to Mr. Matlala's legal team extends over months, not over days. So that's just to address the founding affidavit and the explanation for the lateness, which I say doesn't assist Mr. Matlala's team. The second point is about the heads. And I'm not going to repeat it because, Chair, you've made the point and Commissioner Khumalo has made the point. Those are legal, that's legal argument. There's a legal team that's assisting Mr. Matlala. The heads of argument could have been submitted timeously, and they weren't. There was no need for consultation in relation to the heads of argument. Preliminary points are by their nature legal submissions. The second point...
Please continue.
On the point of the legal submissions, you would have seen from our answering affidavit that we set out the legal principles. It's not true that this is not circumstances that have arisen in a commission before. That is not correct. The authority that we have submitted to the commission that we say is the controlling authority is the Secretary of the Judicial Commission versus Zuma, the Constitutional Court judgment, and specifically the judgment by Justice Jafta, which was a unanimous judgment. And we referred to paragraphs of that judgment, which we say is the governing authority to be considered here. So the law on how one should deal with the assertion of the privilege against self-incrimination in a commission.
Just explain the point about the judgment having been unanimous.
The judgment by Justice Jafta on the point of self-incrimination and the assertion of the privilege against self-incrimination in a commission of inquiry. So that's the judgment on which we have relied. We set out the legal principles in the answering affidavit even before we filed our heads. That's just in relation to the point on the privilege, the section 3, subsection 4 point. The second legal point was in relation to unconstitutionally obtained evidence. And there too, we set out the legal principles in the answering affidavit even before we got to the heads of argument. And the point I'm making is that these are legal submissions. That's why our affidavit sets out the legal principles. And there we explained why the argument that Mr. Matlala is entitled to blanket immunity from questioning in relation to broad categories of topics is not available. It's not a competent relief that they were seeking from this commission. That was already set out in our answering affidavit. So it's not correct that there's no law on this and that they needed to have more time. Quite apart from the important points that you and Commissioner Khumalo have already made, that this is something that's been brewing for some time by Ms. van den Heerfer. The third point is just in relation to, I just want to correct the Dlamini affidavit. It's true that the Dlamini affidavit was filed with the commission and submitted to Mr. Matlana's legal team this weekend. But that's not part of the application that's before the Commission today. It's entirely separate. And that should not hold up the argument on the application. Those actually are my submissions. Chair, I think that the Commission will decide on how much of time, if at all, any time is to be granted to my learned friends. But the argument is there from our side. We are ready to respond. Our concern as evidence leaders, as we've set it out in the heads of argument, we wish to have the application dismissed, and we want the questioning of Mr. Matlala to proceed immediately because time is short.
Thank you,
Chair.
Ms. Hassim.
I'm sorry, Chair. There's one last point
Yes,
that I've
yes,
forgotten,
yes.
and it's sitting here in front of me. I'm sorry about this, Chair, but we also received communication yesterday, and this is something that perhaps my learned friend will want to consider and advise on. It wasn't apparent to us yesterday whether, in fact, Mr. Matlana's legal representatives were abandoning the application. And I say so because last night at 20:51, we received an email from his attorneys. And the email says the following, if I may read it into the record, Chair. It says, "Good evening, evidence leader. We respectfully request your urgent written clarification regarding the scope of permissible questions on record. As discussed yesterday, certain questions are excluded due to the pending criminal matter. We attempted to send an email to this effect, but it appears our system may be experiencing technical difficulties. To avoid any procedural uncertainty, kindly confirm in writing which questions may be asked and which are excluded. This confirmation is necessary to ensure proper management of the record and safeguard procedural fairness. We would appreciate your written response." The response to this letter was as follows. Greetings and salutations, and then please note that until the commissioners rule otherwise, there are no questions relevant to the terms of reference which we treat as being impermissible. So that was the correspondence between the two sides yesterday. It was quite confusing to us what the meaning of this was, because what it suggests is a request for the questions, what questions we intend to pose. From that, we thought that maybe the approach being taken is to proceed on the basis of pose the question and then the privilege will be asserted once questions are posed. And so I think that my learned friend may need to just also clarify that.
Ms. Missy, does the letter mean that the application is abandoned, or what does it mean?
Chair, no, the application is not abandoned. The reason for the email is we're trying to anticipate an instance where the ruling perhaps doesn't go in our way. And Chair, based on the ruling that you would make, then Mr. Matlala would then have to apply the right against self-incrimination as and when the questions come. And I believe the thought process was that when it comes to those topics that he cannot claim privilege over, then what are those topics that we can anticipate an engagement over so we can prepare with regards to that? It was not to indicate in any shape or form to my learned friends that we are abandoning the application.
Yes, I must say that it was a very strange request. One can't quite tell whether the request was for all the questions that are going to be asked to be itemized, which would be something that's unheard of and in fact quite bluntly very strange.
Chair, I do take note of the wording as well, the confusion that would have come from it, but my understanding was that I think the attempt was to ask under which topics are you going to proceed on once the Commission has made a ruling with regards to whether we can proceed, or the argument that we make brings the entire process to a halt. Thank you, Chair.
Thank you. May we see council outside, please? The application for a postponement to tomorrow is refused. Mr. Matlala's application must be argued at 12 midday today. Let's adjourn and resume at 12 midday.
All right, it's 29 minutes past 11. We are ready to resume. Please again make sure that your devices are quiet, switch them off, or put them on silent. Thank you.
Ms. Missy, we were advised that we should come back earlier than midday, and that this was at your instance. Yes.
That is correct, Chair. When we were excused or stood down, rather, we received further instructions from Mr. Madlanga, having heard the engagement that we had prior to the stand down. And the position that is taken is that he feels that it's unfair that the commission is putting him in a position where he has to proceed where his lead counsel, one, is not here, obviously not of her own doing, but because of an illness that became rather sudden in the manner that it's attacked her. Two, because we've intimated that we've not prepared our heads in written submission, he's of the view that he's not comfortable to proceed because that implies that we're not properly, we're not fully prepared to represent him. And so his instructions are that if the commission is not willing to at least grant us this afternoon to ensure that we have those documents before you and that we have our heads put together properly, in the alternative, he has no option but to instruct us to bring an application interdicting the proceedings of this hearing, pending the review of the decision for us not to get a stand down until tomorrow.
You said something about this afternoon, and now at the tail end you say something about tomorrow. Can you please clarify?
Chair, you'd recall when we began our discussion earlier on, we were requesting that the commission stand us down until tomorrow morning, at which point we had made an undertaking that we would have served you with our replying affidavit and our heads of argument. And so what the instructions are is that our application on an urgent basis would interdict the proceedings of the hearing or him giving testimony pending the reviewing of the ruling that you would have made, which is that we must proceed with arguing this matter, because he's of the view that it's unfair that he's been placed in this position where he has to proceed without Van der Heerver, who is his lead counsel, and without heads of arguments before you, which he believes then implies that we are not properly prepared and we're being strong-armed into proceeding.
Now, this time around, you've not said anything about the afternoon. It's what you said about the afternoon that I want to understand.
Yes, Chair, what I meant is that if we stand out now, it'll imply that we only have this afternoon and evening, I suppose, to ensure that we get the documents before the commission. So that's what the afternoon referred to, that if you do change your ruling into us standing down or postponing until tomorrow, it means that it's just this afternoon that would have to ensure that we have bring the documents or serve them on the commission and the evidence leaders. That's what the afternoon was.
Oh, you keep repeating that because you don't have your written submissions, you are not ready. Written submissions, yes, they do assist legal representatives, but in the main, written submissions are prepared for the assistance of the decision maker and not so much the arguer. Do you want to address us on that distinction? So those would more have been of use to us, but seeing that the written submissions are not there, we are prepared to forego the assistance we would have received from your written submissions. So as I say, it's more for us than for you.
Chairperson, having engaged with client afterwards stood down, and obviously with what he had heard during our discussion, his instructions to us is that his observations and his views is that if Ms. Van der Heerver is not here and we have not prepared our arguments for you, it implies that he's not going to be properly represented and he's not comfortable proceeding, which is why he's intimated that should the ruling not be changed to allow us to stand down till tomorrow, it implies that he's of the view, rather, that he's being treated unfairly and he would rather approach a court to have that addressed, Chair. And I do note that you're distinguishing the difference between written submissions and who exactly they're meant to assist, but it's client's instructions that he's of the view, if his lead counsel is not here, together with us having not produced the heads before this commission, that he's not properly represented. And unfortunately, I can't comment any further than that because, as you do know, myself and my junior, my apologies, Chair, I forgot to put Ms. Brighton onto record. She's the third junior on the matter. And consequently, he's of the view that he's not willing to proceed, and he would like an opportunity to have this addressed before a court, Chair.
May I ask an issue that we did not raise before? It is this. Why is it that there is no substantive application for a postponement with sufficient clarity? Now it has just been emphasized to us that, as I understand it, the main reason is the fact that lead counsel is not here. Why is it that no substantive application for a postponement on affidavit was brought?
Chair, I think, for one, we did not anticipate that we would find ourselves in a position where we were not able to, firstly, consult with Mr. Matlala yesterday to get the additional information that we needed. Before we left, I did intimate that there is a document that is imported and it speaks to one of the bases upon which we bring this application, but it's obviously of a factual nature. He had to bring it here in the morning, so that's one element. The fact that we didn't anticipate not being able to prepare the replying affidavit. Number two, that then created circumstances that follow when we were not able to proceed and prepare the heads of argument on time to be before, to serve on the evidence leaders and for the commission to have signed off. And so those are the reasons why we were not able to prepare ourselves on time to, or rather, finally, we hadn't anticipated that Ms. Annaline would fall so ill to a point where she's unable to even be here in person. Because perhaps her being here in person as the lead counsel, we would have had a better argument, so as to say, and it maybe have created way for us to proceed to argue on a legal basis. But one thing I can say is that our instructions from client is that if his lead counsel is not here, he's not comfortable and he doesn't feel properly represented.
But the main reason throughout for not proceeding today is the fact that you did not have all the documents you think you require, and that was known for quite a while back, and that had nothing to do with Ms. van den Heever's being here or not being here. So at some point, especially because this morning a postponement is sought on the basis that these documents are not available. Your argument, that was the gravamen of your argument this morning. A reference to Ms. van den Heever not being well was something that was said in passing in your argument. Main reason, the fact that no replying affidavit had been filed, and also the fact that written submissions had not been filed. So the short point I'm making is that that's something that was known for quite a while. At some point, a decision should have been made that, seeing that we don't have these documents, and because we do not have them, we are going to seek a postponement. Let us bring a substantive application for a postponement. That's the point I'm making. The issue about lead counsel not being here arises because I have now directed that I want to hear, that we as a commission want to hear argument on the application, on the points in limine. That's when now the issue of Ms. van den Heever's absence takes center stage, and that has nothing to do with why this morning you argued that there should be a postponement. I hope you do get that distinction. Can you address me on that distinction in particular with regard
Chair,
to...
I do
Just
get that-
let me finish. With regard to why there is no substantive application.
Chair, firstly, I'm just getting notes from a junior. Ms. Van der Heever would have been prepared to argue the matter whether there were papers before us or not. That's the first point. Secondly, we don't anticipate an instance where she would be ill and not be in a position to appear before the commission, which is why we were unable to prepare a written postponement. Because in the morning when we engaged with her and she was being rushed to the hospital to go and have her ailment addressed, we hadn't anticipated that she would not be here in person in time for us to then prepare a written postponement application. What I can assure is that the letter that you sent indicating that you haven't received a postponement application and will proceed absent of that application, we received it at around past 7 in the parking lot of the venue where this commission is being heard. And so, Chair, could we have prepared the postponement application? If we were in this position that we found ourselves in the morning the night before, we would have endeavored to prepare the postponement application. That's with certainty. But because this is something that happened to us in the morning and my instructions were to come before the commission and to ask us to postpone only till tomorrow, that's the reason why you don't have a written postponement application.
Now, I just want to get an idea of how things are to unfold. In the event that I'm not saying we are adopting that stance, but in the event that we adopt the stance that we go ahead with the hearing of Mr. Matlala's application, how will things unfold then? Will you walk out? Will you withdraw as Mr. Matlala's legal representatives? I just want to get an idea of how things will unfold. Going further and saying, if we get to a point, and underline if we get to a point where, having heard Mr. Matlala's application, we do not grant it, and we go ahead with the hearing of his evidence in the normal course, with him, of course, being entitled to raise whatever privilege he may want to raise. So I want you to address me with regard to how things unfold, even looking ahead up to and including that furthest or farthest point.
So, Chair, as you rightly pointed out, it's either one of two options, which is the fact that it would be removed off the brief as his counsel and possibly even his attorneys. The alternative being that you would grant us another ruling, which is perhaps to say within a certain period of time, please ensure that you've served and filed this urgent application with your Part A and your Part B to review my ruling, and at which point would get the opportunity to do so. I must say I wouldn't have...
The application, the interdict, I assume that's a High Court interdict, so
Yes.
time frames with regard to that would have nothing to do with us. So...
Chair, when I refer to the time frame,
Yes.
I'm referring to in terms of us ensuring that we've served you here and not what the High Court or the senior judge sitting would determine would be the ideal time for the urgent to be heard. That's just, again, ideas that I'm throwing out.
And may I, sorry to interrupt you, and as you are making your submissions, again, bear in mind, I started with two big ifs. If we reach that point, you should be aware that there will be no interdict in existence at that point. Which would mean that nothing stops the commission from going ahead and hearing Mr. Matlala's testimony.
Chair, As I said, that we hadn't foreseen an instance that the commission would possibly consider not granting us an opportunity to approach the High Court and address the application that we seek to be heard on an urgent basis. And if that is the case, I don't want to preempt what we would do if you decide not to grant us that opportunity, because for me it's a matter of you're either changing your ruling, allowing us to stand down till tomorrow. The alternative, you say, no, I'm not granting it, at which point the question as to whether are you going to rule, to say, okay, since you've intimated that you want to have my ruling heard on an urgent basis and reviewed, then you are welcome to do so, I excuse you. But if you choose to proceed without excusing us and thereby Mr. Madlanga, I would then ask for a stand down, because then there are implications on him that would affect us, i.e. for one, walking out, and who gets to walk out, and if, for instance, counsel is removed off the brief, what are his options? And should he decide that he wants to walk out with us because he feels that he's being unfairly treated and is not being given an opportunity to be heard till tomorrow morning, with our undertaking being that whether Ms. van der Heever is here or not, we would have to ensure that I, being then the lead counsel, is prepared to continue and present before the commission. Then again, as I stated, we hadn't taken instructions, but then I think it would give us, if you could give us an opportunity to stand on further, depending on what your ruling is, to engage with him and consider what the implications would be, because there are different implications should you decide to protest and want to walk away, and who gets to do the walking away, and what those implications as well would be, Chair. I think it's wrong for me to preempt the instance where we decide, because walking away seems to imply that we are protesting, because we'll be walking away in protest. And if you walk away in protest, we've seen in previous instances what the implications are, and the client would have to consider that, and he'd have to give us instructions, Chair. I can't preempt to answer your question.
Thank you, Ms. Missy. Ms. Hassim?
Chair, I've been listening closely to my learned friend, and it feels like the reasons keep shifting for how we've come about to be in this position. Whether it's because the last submission that Ms. Messi made was that she would make an undertaking to proceed to deliver the argument in the absence of her leader. But if that is the case, then what would be the need then for the postponement? So, and for the urgent interdict? It's not entirely clear to me. It seems to me that, and I have some sympathy for Ms. Messi and Ms. Brighton, that juniors are placed in a difficult position where they have to step into the shoes of their leader. The leader has become unavailable for reasons not in her control. This is what happens in practice, and we are often called upon to step into the shoes of our leader on short notice, and to be prepared to do so. It's not an easy position, but it is one you assume when you take on a brief and you're junior counsel. While I have sympathy for their position, it doesn't absolve them of their obligation to take the place of the leader. They were aware that Ms. van der Heever would not be available today. This could have been brought to our attention much sooner. One of the reasons that was advanced by Ms. Messi for the delay was the inability to consult with the client. That is not a ground, an adequate justification for a delay. That was in response to the chair's question about why didn't you bring a postponement application? Because it isn't the inability to consult on the law doesn't avail Ms. Messi on this. This is a legal argument that is to be made. So, and I've been instructed to put something on record. And I do so without having had the opportunity to make it, to alert my learned friend of this, because it's only came to my attention now while I'm sitting here. And it goes to the point of the complaint by Ms. Messi of the inability to consult in the
Is it
commission.
not Missy? Is it?
Miss Missy, apologies.
Yes.
Maybe I've got soccer on my brain. It's only come into my possession. I'm instructed to put it on the record. And it's a message from the Area Commissioner for DC, Department of Correctional Services, Commissioner Khoza. And what he says, and this is received at 11:36 this morning, and as I said, I'm instructed to put it on record. I'm not going to read the entire thing into the record, just the factual part, not the comments, if I can put it that way. So the relevant part of the message is facts provided are not true. I am not even aware of the challenges advanced to the Commission. I think the challenges that were complained of. And then the next message, they consulted for 3 days and we are prepared to make concessions anytime because we understand the importance of the Commission. I checked with the head of the center, Mr. Kabengu, on all these challenges. He also denied to have created any disadvantage to them. So that's a message from the Area Commissioner Khoza. And as I said, Chair, I'm just putting that on record. None of that actually changes the legal position that is before you. And the legal position is that a stated intention to launch an urgent application does not itself suspend this Commission's proceedings. Unless and until there is an order from a High Court that interdicts the Commission from proceeding, it can continue, subject, of course, to the Chair's discretion to adjourn. And maybe what I should do on that score is just refer the Chair and the Commissioners to two authorities. And the first is the Constitutional Court judgment in City of Tshwane, Metropolitan Municipality versus AfriForum. And it's 2016, volume 6 of the South African Law Reports, page 279. And as I said, Chair, the judgment of the Constitutional Court, and the relevant paragraph is paragraph 74. And then, as it happens, the other judgment I'd like to refer the Commission to is actually the Zuma judgment, but not the one I made reference to this morning, which was Justice Jafta's judgment. It's the other judgment, Justice Khampepe. And the citation of that judgment is Secretary of the Judicial Commission of Inquiry into allegations of state capture, etc., versus Zuma. 2021, volume 5.
Sorry, there was a cough. Volume?
Volume 5.
Thank you.
SA Law Reports, page 327, at paragraphs 94 to 95. So with those, that's also, yes, it's Acting Deputy Chief Justice Khampepe writing for the majority. So with those legal submissions, Chair, we request that...
What do the cases say?
Let me take you to
You don't need,
the City of Tshwane.
You don't need to quote verbatim. You may just tell us the substance.
Well, it supports a proposition, Chair, that proceedings are not halted pending an intention to bring legal proceedings. It's not halted even if you have brought the legal proceedings, and of course we know here there hasn't yet been a filing of an urgent application. It is a stated intention to file an urgent application. So that's the proposition. Well, let me just say, Chair, if I could just quote this one short aspect of the City of Tshwane judgment at paragraph 74. It reads as follows: it needs to be stated categorically that no aspect of our law requires of any entity or person to desist from implementing an apparently lawful decision simply because an application that might even be dismissed has been launched to hopefully stall that implementation. Any decision to that effect lacks a sound jurisprudential basis and is not part of our law. It is a restraining order itself, as opposed to the sheer hope or fear of one being granted, that can, in law, restrain. To suggest otherwise reduces the actual grant of an interdict to a superfluity. That's a paragraph to which I referred the Commission to, Chair. So with those submissions, we request that the application from the bar, as it were, for a postponement should be dismissed, and that we should be in a position now to proceed with the questioning of Mr. Madlanga as has been planned for some time.
I think the questioning would, if we do get there, the questioning would come after, depending on whether the legal representatives will indeed not be here, but the questioning would have to follow after Mr. Madlanga, if he's all by himself, has been afforded an opportunity to move his application in person. So we won't, assuming that we are with you,
yes,
we won't straight away go to the hearing of Mr. And again, assuming,
Chair,
I was once misunderstood by counsel, and we had an unfortunate heated altercation, he and I.
We don't want to have a repeat of that.
So,
I understand the Chair clearly.
Yes.
Of course, and I don't wish to preempt any deliberation and ruling by the Chair and co-commissioners.
Yes. Yes.
My submission is merely putting forward the position of the evidence.
That actually takes us to a request that was made by Ms. Missy when I asked her how things would unfold if, and Ms. Missy requested a brief stand down for her to take instructions. I would assume you have no objection to that.
I have no objection, Chair.
Yes. Ms. Missy?
Chairperson, I did miss quite a bit of your interaction with Ms. Hashim because I was trying to figure out how we're going to reply to the submissions that she's made. Am I going to be given an opportunity to respond to the message that she received? I want to ask that first.
Please do respond, yes.
Firstly, Chair, the only thing that I will say is that those submissions were with regards to from Friday up until Sunday, the filing of our founding affidavit, together with our consultation towards preparing a replying affidavit and the heads of arguments. It does not speak to any interaction prior to that. Secondly, if I'm being challenged on the submissions that I've made to this commission with regards to that on a factual basis, I do believe the timestamps of when I went in and went out, because I was present on Friday and I was also present on Sunday, can be looked at. That will show you how long I waited, where I waited, what happened, and ultimately, for example, at what time I got the opportunity together with my learned friend, Ms. Brighton, to eventually sit down outside of the Correctional Service Center and email the signed affidavit. So with that being said, Chair, I can only say that. If I'm being questioned as to whether I'm misleading the Commission or I'm casting a particular view about the Correctional Service Center, I'm not. I was simply saying that the Commission is not aware, and any layperson out there is not aware that they have rules and they keep to their rules. And that has affected how we operated on Friday, Saturday, and Sunday. But if I'm being questioned, the timestamps, and I'm sure they have recordings, the times we signed in, as well as cameras to indicate whether I'm misleading the Commission or not. That's as far as I can take it.
Thank you. There is no way that based on what we are told from the bar, from both sides, there's no way, seeing how contradictory the two versions are, that we can take a decision on that. And in fact, I think for present purposes, it's not even necessary for us to take a decision or to go there at all. Do you wish to reply to the rest of...
Chair, sorry, that threw me off a bit. Oftentimes when you are on the legal representative side and you're being called to question about whether you're lying or not, it does throw you off because it speaks to your integrity as a legal representative. I wanted to, because I believe in our earlier engagement, I wanted to distinguish between the position that's been taken by our client, Mr. Madlanga, as well as the arguments that are made earlier on, Chair. So the arguments that are made earlier on are in relation to us, whether we can proceed and why we're saying we should stand down till tomorrow. The second element of it, having come back and taken instructions from clients, those are his instructions about how he feels in terms of us having to proceed. Should you insist that we proceed today and not wait till tomorrow? So there needs to be a distinction between the two. We're not shifting the goalposts from this is what we were saying earlier on in the morning and now we're changing and we're saying this here. What I spoke to mainly now that we've come back after the stand down is with regards to the instructions and his observation, how he feels about it. The earlier part still stands as it is, where you are asking us and we have to address you as to whether we proceed or we don't proceed, and you made the ruling that you made, which is that we proceed at 12:30. So I just needed us to make that distinction.
You do still need this stand down with regard to how things will unfold in the event that the decision is we are going ahead.
Chair, we still do need to stand down, but we had a discussion when we were hoping that it doesn't come off as if we're being hostile, because it somewhat has underlying for us that, oh, so now you need to go and preempt, are you going to walk away from us? It gave that impression, but if...
No, it's just wanting to know how things are going to unfold. There's nothing judgmental about it, and I have not observed any hostility. I just want to know how, if we do get there, again, underline if we do get there, what's going to happen?
Chair, I would appreciate the stand down. Chair, I would appreciate the stand down to just quickly take instructions from client, and then I'll come back with a response if you do decide to otherwise.
Yes, thank you.
Noted, Chair.
Thank you, Ms. Hasim.
Chair, it's very important for me to make one remark.
Yes.
And it's in relation to the message that was received by the area commissioner. My instructions were simply to put it on record.
No.
I take no position on whether my learned friend, Ms. Missy, is misleading this commission or anything like that. That's not my intention, and I do not wish to be misunderstood at all to be suggesting that. It's simply an objective message that was sent through that I put on record, and I think perhaps what it is from the commissioner's side to say we are not being obstructive. But the fact that it is difficult to consult with a client who is incarcerated, if any of us who have gone through that understand that it's a difficult process. And so I just wanted to make that clear.
An important takeaway actually from that text is this, as Ms. Missy was arguing this morning, I actually did think of the possibility of the commission engaging with the prison authorities to ensure that the difficulties Ms. is telling us about do not recur. Now, a good take-home or take-away from this text is that such an engagement will actually, there will be no resistance to the request that I already had in mind.
Quite so. Thank you, Chair.
I will not indicate it. Yes.
Chair, my little friend just highlighted something. I did speak about how we often use our cell phones for internet. We use our cell phones to get Wi-Fi through them to connect to our phones. If that request could specifically include that we have our cell phones, because that would really make things easier for us should we have to engage with him later on, to allow council at least one cell phone to come in with us. We don't all have to have our cell phones with just one cell phone so that we don't have this issue of internet not being present, etc. Because what would happen is that, for instance, if we need to have a document and he's happy with it and we have to file it, it's just a matter of him signing it. We can scan using our phones. So, and then we would be able to send it immediately and wouldn't have all these issues of we don't have the internet, we need to leave, we need to come back, etc. So a request that just specifically include there that we are allowed to carry in one cell phone for purposes of having access to the internet.
That will be considered.
Thank you, Chair.
I'm saying considered. Let's adjourn. I will not indicate a time.
You'll tell me when you want to.
Yes, Ms. Missy.
Chairperson, thank you for giving us the time to deliberate over the hypothetical questions. The first one being that in a perfect world, we would anticipate that you would say, yes, I'm giving you the additional hours and I want those documents, and whether you're prepared or not, tomorrow proceeding. That's when we win and we get our kitty and we walk away. In the instance you rule that no, we are proceeding, our options would be to go off record as his counsel, and he would be without representation, it implies. Given the fact that
Counsel only or counsel and attorneys?
counsel and attorneys.
So, or you will no longer be representing him?
That's correct.
Yes, yes.
So that would be the hypothetical scenario that we'd find ourselves in if you decide that you're not willing to give us the additional time to come through prepare tomorrow. Again, I do want to stress the undertaking that we're making, which is that should you decide to rule to give us the additional time, whether Ms. van der Heerwe is here or not, we will be proceeding to argue. Whether you have received the papers or not from us, we will proceed to argue orally with or without the papers.
You say when?
Tomorrow morning.
Tomorrow.
Should you decide to rule in our favor that we should go home and come back tomorrow prepared. What I'm intimating or suggesting is that the scenario you would have is that whether we file the documents or not, we will be proceeding to argue. Thanks, Chairman.
Thank you, thank you.
Ms. Missy, when you say off the record, you mean you withdraw as his legal team?
That's correct.
Would that go for Ms. van der Heerwe as well?
Those are the instructions that I received as well with regards to, so it would be the entire team.
Okay.
Thank you, Commissioner.
Oh, and there was...
was another team you speak.
Yeah. When she placed you on record, Ms. van der Heerwe, last time, she said there was another firm of attorneys as well. Are they present here, and do they also withdraw? Because it's not just the people that are sitting behind you as we understood here.
Yes, I actually just realized right now that Mr. Madlanga is and his firm still is part of this team, so they would also withdraw from there. Can it be the entire team, all attorneys and counsel?
That's your instruction from Mr. Madlanga?
Those are our instructions.
From Mr. Madlanga?
That's correct, hypothetically speaking.
Okay.
Yes.
Mr. Madlanga is not with you. Has there been a discussion with him? Because it's important that we don't end up with a situation where, if this eventuality that you're contemplating happens, that we don't end up with a situation where he comes to the commission and said, I never put myself off record. The team that was here on Monday were not speaking for me, and I hadn't spoken to Mr. Madlanga. So I think it's very important that we are clear about that.
I'm glad that you raised it, because that could potentially happen, hypothetically speaking. And with that being said, because these are instructions and engagements that we had with Mr. Madlanga, and Mr. Madlanga is not here in person, I suppose then, in fairness to him, he has not commented on that element. These are just instructions that the entire team would be off record. But I suppose in that instance would have to engage with him and consider his stance should we find ourselves in that position. I suppose there won't be a need for us to stand on further until we've had a ruling. It just gives an idea of where we potentially would be. And if that is the case, we'll engage him and inform the Commission of his position.
Yes, I think, Ms. Missy, this eventuality that you're contemplating, I think it's very important that we all are clear what it is you're saying. You are using language of off the record. My experience is counsel say, I'm withdrawing. I'm no longer on brief. I'm not counsel on brief in this matter, and I'm withdrawing because for their personal reasons or because that's the instruction from the client. So just so that there's no confusion, can we clearly understand you? You are saying in the event you do not get, I'm going to say your way, because that's what it is. If you don't get your way, or Mr. Matlala's way, you are saying to us your instruction from Mr. Matlala is that the entire legal team, and I'm happy to leave aside Mr. Maluleke for now, you're saying your instruction is that the entire legal team, counsel and attorneys, including Mrs. van den Heever, you withdraw as counsel.
That's correct, Commissioner.
Okay, thank
That's
you.
correct.
Who is the senior attorney? This is something that that's so crucial that I think we should hear from the attorneys directly. Who is the senior of the attorneys? And can
That
you
would be Mr. Baloyi.
please come to the microphone and. No. Please state your name for the record
Thank you, Commissioner.
and your firm.
Yes, it's Mr. Baloyi with initial N from Baloyi Attorneys in Pretoria. Yes.
I asked if you also confirm that if our decision is that we proceed with Mr. Matlala's application, is your decision that you, as Mr. Matlala's attorneys of record, are withdrawing from representing him? If our decision is that we are proceeding, is that, do you confirm what counsel said?
Yes, I do confirm the submission made by the council.
You will be withdrawing, yeah. Perhaps, thank you very much, Mr. Baloyi. I think we've reached the stage where we should. Ms. Asim, I'm not sure that you would want to say something, but perhaps because this is not really your decision, if haven't we reached a stage where we should just indicate what we think?
Chair, there was
or what I think, because I think our regulations and rules really say that process-related decisions are mine, and indeed all rulings that have gone out go out. Even if signed by the Commission Secretary, they go out under my name. But of course, for practical reasons, I'm always assisted by my co-commissioners. But ultimately, it's my decision.
Chair, there's
Yes.
nothing that I can usefully say in response to the last
Yes,
submissions that have
yes.
been made about withdrawing, etc. So it's in the chair's hands.
Yes, thank you. I will address Mr. Matlala directly on this. Mr. Matlala, I just want to get an idea whether you two confirm that after your counsel or legal representatives were afforded an opportunity to consult with you, what was agreed upon is that if my direction is that we go ahead with your application, they will then withdraw as your legal representatives.
Thank you, Chair.
Can you please switch on both microphones? Yes, thank you.
Thank you, Chair. Chair, we had 3 scenarios, so I'm actually in the dark now because while I was having lunch, I didn't have enough time to conclude what we've been discussing, so we just came right straight here. So I do not know whether my legal counsel, what they are saying now is what comes from Mrs. van der Heever as instruction or not. So I'm actually in the dark. I don't know what to say.
So basically, you are not really party to what has been announced.
No, we've discussed the options, yes,
Okay.
but I haven't had the time to make up my own mind. So,
All right. Maybe the best is for me to announce the decision. Having considered everything that has been presented to the Commission, my decision is to go ahead to hear Mr. Matlala's application. That's the decision. Ms. Missy?
Chairperson, given the fact that Mr. Matlala, being our client, has now confirmed that he hadn't settled his mind because we labored under the impression that this is where we're standing and these are our instructions, given the fact that he's of the view that he feels confused now, he's no longer with us, will you please grant us an opportunity to then finalize and get the instructions so we don't have this situation again?
Ms. Missy, the withdrawal of counsel and legal representations is not, strictly speaking, a matter of instruction from client. It's ultimately a decision taken by the legal representatives. They choose on their own for whatever reasons that we have now reached a point where we can no longer represent our client. Therefore, we are withdrawing as legal representatives. I don't know whether you are now suggesting that it was not a properly considered decision. I'm not pushing you to withdraw if you've suddenly become ambivalent about it.
Chair, remember we were operating under hypothetical instances. Now that we know definitively what your position is, I do believe that we ought to be given an opportunity to finalize if really we're sticking to that position of walking away or not. As you've noted, that perhaps we might feel a bit ambivalent and would feel we want to continue. This was what we're simply requesting, Chair.
Ms. Missy, what's happening now is deeply problematic. I asked you directly, is it your instructions from Mr. Matlala? You said yes. That's deeply problematic. Whatever stand down you get to go and consult with him, I would like you to end on that note from me. It's deeply problematic what's just happened now, and I hope you find a way to address it. Because what it suggests and represents is what you said in response to my direct questions, is that is not the true position, given what Mr. Matlala is saying now. If you come back to say it was a misunderstanding in whatever form, that I'm prepared to grant you that, but it is deeply problematic. that you have put firmly, those are your instructions from your client. And now you say, well, maybe we need to go and discuss. I want you to understand my concern about it.
If I may, Commissioner, I do understand your concern about it, and that's the reason why I specifically have asked if the chairperson, the commissioners, could let us stand down, because I was laboring under the fact that those are our instructions. Now that he has intimated that he does not feel that he's on the same page with us and he does not understand, that implies that there's been a misunderstanding, and that's the reason why I would like for us to address this, so that when we come back before the commission, then we don't have this issue happening again. And to add over that, if you recall, this is a hypothetical situation that we're talking about. Now that you've made your ruling, that implies that we need to come back to the chairperson with a final decision of what are we going to do. Chairperson, I don't know if...
And as I said in my ruling, at this point, this is only about hearing Mr. Matlala's application. We have not reached the stage of the continuation of his testimony. That's where we are, just for clarity.
Thank you, Chair and Commissioners.
And Mr. Matlala, you are fortunate to have had lunch already. We are yet to have ours. No, I'm mentioning that because you said when you were having lunch earlier during the break that we had. Because it's 3 minutes before the lunch adjournment, maybe let's just take the lunch adjournment and resume it at 2 p.m. And let's hear from you, Ms. Missy, at that point.
Thank you, Chair.
And I hope everything will have been clarified, and that one way or the other will then hear Mr. Matlala's application, whether you continue to represent him or whether he is moving it in person. Let's adjourn and resume at 2 p.m.
We're about to resume. It is 13:59. Please, again, make sure that your devices, your cell phones are off or on silent. Please stand. Thank you.
Ms. Missy?
Chairperson, we have consulted with the client, and with regards to the misunderstanding, he would like to address the commission about the misunderstanding relating to the issue of the hypothetical scenario and the instructions that he has given us. May he be granted the opportunity to do so?
Thank you. Yes, Ms. Machala.
Yes, thank you, Chair. Chair, I was of the view that the question that you raised to me was a final question that I'm terminating my mandate to my legal counsel, and hence, before that, I explained that we explored 3 scenarios.
Oh, please switch on your second mic, please.
I'm sorry about that.
No problem.
Yes, I'm saying it's a huge understanding because my counsel was raising the scenario as hypothetical, and then it was not a final thing. So I was of the view that your question was, am I terminating my mandate to my legal counsel? And then hence I said I was in the dark. But obviously it was a very huge misunderstanding, so I wanted to clarify that.
Now that this is no longer hypothetical and I've made a ruling, what's the position now? Do I hear you, Ms. Missy, or do I hear Mr. Matala?
Chair, you can hear me on that. Chairperson, we've deliberated with Mr. Matlala, and he has requested that we remain on brief as his counsel and other attorneys of record. The position that we found ourselves in with the legal advice, given the circumstances that we face, which is one that Ms. van der Heever, as you correctly pointed out, has been preparing on these points for as long as she's appeared here. And we've come in at a later stage and are not properly prepared to argue these points, and he's not comfortable with it either. His suggestion was that we could proceed with the hearing as is, and then he reserves his right to claim privilege as and when the questions are posed to him, and if necessary would then advance arguments before the commission.
And what should we consider the status of the application to be? I'm happy for us to go along those lines. But what is the status as a matter of law? What is the status of the application then? I'm not pushing you to.
It sounds like
yes, it's actually a practical. Maybe let's just go ahead then with the evidence. That's what Ms. Missy says.
Thank you, Chair.
And as the answering affidavit of the evidence leaders and written submissions say, it's still open to Mr. Matlala to raise privilege. Nothing stops him from doing so. And I also understood you to be saying exactly that, Ms. Missy.
Chairperson, those are our instructions
Yes.
from him, that he still reserves his
Yes,
right as
yes.
and when you ask the questions that he raises the privilege against self-incrimination.
Yes.
I do have one point that I received, we received instructions about earlier this morning after considering the last affidavit that we received. I don't know if we could be granted an opportunity to address it before we proceed, because we do deem it pertinent that it's addressed, and you can give us
What's that issue?
the issue regarding the affidavit that was deposed to by Mr. Dlamini, the senior investigator.
Let's just proceed with the testimony, unless Ms. Sillo is proposing to start with that. Let's just proceed and avoid that affidavit because a lot of time has been wasted already.
It has, Chair, and I definitely am not starting with that affidavit.
Yes, yes.
And I think I'm looking at the time. Chances are that we are unlikely to get to the affidavit today, just to put it out there. But I see Ms. Hassim wants to say something.
Oh, And yes, Mr. And I forgot to say, and you are excused, but let me hear you.
I'm afraid I'm not excused because I'm responsible for this witness as well.
Yes.
It really is to just close the loop,
Yes.
Chair, on the application that was brought.
Yes.
That to say that the commissioners have the written submissions of the evidence leaders, and just for the sake of the record and for everyone to understand what the meaning of it is, we obviously do not take issue with Mr. Matlala's right to assert his Section 3(4) privilege against self-incrimination. What the problem was with the way in which they brought the application was asking for a blanket immunity from whole swathes of parts of the evidence, which would have undermined this commission significantly. So on that understanding, Mr. Matlala is free to assert his right himself and as he wishes, and the chair will make a ruling on it at the right point. Thank you.
Thank you. If you are able to, Ms. Sillo, maybe just try to avoid the issue of that affidavit for the rest of the day, but only if it's practical for you to.
No,
Please, yeah.
I confirm it is, Chair.
Yes.
I have a few issues to engage Mr. Matlala on without having to touch on that affidavit.
Thank you.
I just need to confirm, and good afternoon, Mr. Matlala. Mr. Matlala should have next to him at least 3 boxes of files. Is that the case?
Yes, I do.
You do. Chair, now, I haven't had a 2-minute stand down for my projector to come sit by me, but we shall make the best of a bad situation.
Let them just walk across or not?
Okay, if she may, I would appreciate that.
The laptop is connected. I was trying to avoid another adjournment. I guess we are forced to. We'll hear from you. Let's adjourn.
2 minutes. Thank you, Chair.
Which files must we take out?
1, 2. All right, we're ready to resume. Seemingly not. Just 1 second. Clearly not. All right, it looks like we've got a green light. Let's proceed. Cell phones off, please. Thank you.
Yes, Mr.
Thank you, Chair. Chair, just a reminder for the record, when we parted on the 21st, Mr. Matlala had asserted his right to supplement, and in fact, he had made certain undertakings to supplement his original statement. Mr. Matlala, do you have before you file 1, which should read Regulation 10.6 Statement and Annexure? That's the original file with your statement.
Can I please check?
You will recall that in dealing with that statement, we first had regard to the Regulation 10.6 notice that had been issued, to which was annexed a schedule with a list of names and names of individuals. And you had been requested in the 10.6 to explain any relationship you have with any one of them. You recall that?
Yes, I do.
And in the course of considering the contents of your statement, it became apparent that you hadn't addressed some of the persons listed in Schedule A. And you undertook to do so in your supplementary statement. Do you recall?
Yes, I recall.
And that's the basis on which we parted, Chair, on the 21st, that he will supplement and provide detail on such individuals that he had not addressed in Schedule A. At the same time, that's when a decision was taken that they will institute this application to raise preliminary points, which they did. The challenge we have is, much as we expected Mr. Matlala and his team to file 2 separate documents, one being a supplement to his original statement and the other being the application raising the in limine points, they combined the 2 to create one document. We have attempted to look at that affidavit that they have filed in support of the application to get a sense of what would constitute supplementation for the purposes that I have highlighted. And with your leave then, Chair, I would invite perhaps Mr. Matlala to address the relationships of the various individuals as reflected in this affidavit, but only those aspects of this affidavit, and not read the entire affidavit as if it is a supplementary statement, if that is acceptable. Mr. Matlala, that was communicated to you, I think, by your legal team, that that's how we propose to deal with this matter of supplementation.
Okay, it's fine.
Okay. Now, if you have your list, then Schedule 8 to the Regulation 10.6 at page 7, you recall we marked those that you had addressed. There is a list of them that you did not address, items 13, I think, to 25, on the basis that, to 24, I think, on the basis that they are your co-accused in the Medicare matter.
Yes, that's correct.
So then, if you look at your affidavit in support of this application brought on your behalf, that would be in the second file, and that file would be marked application for immunity, supplementary affidavit. Do you have it close by?
Yes, I have it.
When I cast my eye on that, I see that up until page 10, you deal with, no, page 12, you deal generally with the basis on which you move this application and you are setting off your constitutional rights. You address for the first time at page 13 the issue of EMPD. And you recall that if you look at the Schedule A at page 7, at item 28, you were requested to speak about Commissioner Julius Mkwanazi. Yes, Commissioner Julius Mkwanazi. And you had been requested to provide an explanation of your interactions and business engagements with such entities as the EMPD, that is at item 2.1.6 of the 10.6 regulation notice. You recall that?
Yes, I do.
Now you respond to that then at page 13, starting at your paragraph 62. I would invite you then to read into the record, by way of supplementing your original statement, paragraph 62 to 65.
I have responded to this question in my previous affidavit. I have been advised to also place on record that I am a suspect in case involving the EMPD, and I therefore do not wish to answer any question regarding my interaction with the EMPD. I attach here to a copy of a statement deposed to by Intervision Cordelia Kabeng, from which it is evident that I am a suspect in a case under investigation by members of the IPID, under case number 262/2023, relating to the unlawful fitting and usage of blue lights. A copy of the statement is annexed here to marked VMSA1. Other companies, I have not done any business with the aforesaid entities through any of my other companies.
Thank you. I'll then propose we jump to page 14 from paragraph 71. under 71, you say, in respect of the individuals I list herein under, I wish to amplify my original affidavit, and then you detail the individuals. Could you read the headings and the relevant subparagraphs to the name into the record, starting with subparagraph 71.1?
I have answered this question when I gave evidence.
Read the name as well.
Oh, sorry.
Yes,
Okay.
yes.
Minister Senzo Mkhunu, I have answered this question when I gave evidence. Former Minister Becky Cele, I have partly answered this question when I gave evidence. I do, however, wish to state that I am a suspect in a matter under investigation which relates to my interaction with him, as was made clear to me during my questioning by IDEC and as was later recorded in the statement I made in terms of the provisions of Section 204 of the CPA. Former General Komoto Patlani, I have answered this question when I gave evidence. Lieutenant General Nhlanhla Mkhwanazi, I have partly answered this question when I gave evidence. I do, however, wish to state that I am an accused in a matter on trial pending before the Johannesburg High Court under case number SS98/2025. I have also noted that Lieutenant General Nhlanhla Mkhwanazi has stated under oath that he recorded the conversation we had on the day I met him. I now invite him to disclose this recording to Commission so everyone can hear firsthand what happened on that day. I respectfully point out that I do not understand why such an important piece of evidence have not yet been subpoenaed or voluntarily handed over to the Commission. Lieutenant General Mule Fefani, I have dealt with this issue in my previous affidavit. Major General Feroz Khan, I have answered this question when I gave evidence.
Thank you. I would then, on my reading, it would appear that we should take it from paragraph 72, because you are responding directly to the paragraphs in the subpoena. You start with paragraph 2.3.2, and just to quickly remind you, that had required you to speak of your involvement in the incident of delivery of impalas to General Sibia and any other forms of gratification given to General Sibia. You deal with that at paragraph 72? 72 and up to 74. Thank you.
I'm a suspect in a matter under investigation which relates to my interaction with him, as was made clear to me during my questioning by IDEC and as was later recorded in the statement I made in terms of the provisions of Section 204 of the CPA. One of the matters related inter alia directly to the issue of the imbalance. Another of the matters relates to payments of gratification.
And then that would take us then to your response to paragraph 2.3.3, and this concerned the circumstances in which Sergeant Ngosi came in possession of your Luxo Africa Bank card. You deal with that at paragraph 75.
Luxo is a co-accused of mine in the Medicare matter, and therefore I cannot comment and or provide any evidence relating to that matter. I therefore exercise my constitutional right not to answer any questions regarding the said matter, as same will violate my constitutional fair trial rights under Section 35, including my right to silence.
And proceeding then to your paragraph 76 to 78 in response to paragraph 2.3.4 of the Regulation 10.6 notice, which required you to speak of your involvement in the loan or funding agreement entered into with Mr. Sulem Karim on or about June 2024.
I have given instructions to my legal team to endeavor to obtain relevant paperwork on the matter relating Mr. Karim. At the time of signing this affidavit, they had not yet obtained anything, and I thus observe my right to supplement this affidavit regarding this aspect. Notwithstanding a thorough search of the records in my possession, I was unable to obtain any documents relevant to the question under reply.
Thank you for that. That will then bring us to a response to paragraph 2.3.5 of the Regulation 10.6 notice, which had asked you to comment on your appearance at the ad hoc committee and whether you were ever induced, threatened, or influenced to give false evidence, including the details of who induced or threatened you to give false testimony, when, how, and for what purpose. You deal with that from paragraph 79 to 83 at page 17, if you could read those into the record.
May I just quickly raise something, Mr. Matlala? It relates to paragraph 77, saying that you thus observe your right to supplement this affidavit regarding the aspect you are dealing with there. I'm not altogether sure that it's a matter of right for you to supplement. Perhaps this is a legal question which maybe Ms. Missy should respond to. And I've seen this point being made a good few times in this affidavit. It was already an indulgence for you to supplement, and something that I granted or allowed without any reservations. I just want to avoid a situation where it's suggested that it's something that should happen as of right. Ms. Missy?
Chairperson, this directly relates to him claiming the rights of privilege in terms of section 3.4. We would be required to show or give factual basis why it is that he wants to claim it. But in order for him to do so, he needed us to find that piece of information that he wanted us to research and provide to him so that we can confirm, in order to allow him, or rather enable him, to claim his right before this commission when it relates to issues that have to do with Mr. Karim.
I read this differently, Ms. Missy. I read this to be saying Mr. Matlala is asserting a right to supplement the content of his affidavit with regard to the issue being raised about Mr. Karim. I did not understand that to relate to the privilege that Mr. Matlala is claiming, or am I misreading this?
Chairperson, you are correct insofar as that he's asserting a right to supplement the affidavit in order for him to be able to claim the right of privilege, because as it stands, he has informed that with regards to why he would want to claim the right to privilege. But in order for us to do so, we'd have to lay facts to it as previously argued rather on last week Monday. But we were not able yet to obtain the information that he needs. And so it put us in a position where we had to answer how would we then later deal with it if and when we do obtain that information that would put the commission into light that indeed he's either suspect or an accused, and therefore he would be in a position to claim the right to privilege.
Can you please take me through paragraphs 76 to 78 and show me where it's intimated that with regard to Mr. Karim, Mr. Matlala wants to raise the issue of privilege? Again, I repeat, I'm probably misreading or misunderstanding.
Chairperson, I agree with you that it doesn't categorically say so. I'm simply explaining why it is that he was asserting that right with regards to claim.
I guess my point is, where do you get that? Where do you get what you are saying? Because I do not see it in paragraphs 76 to 78.
Chairperson, in that instance, the only submission that I can make is that should we have come across or should we obtain that piece of information, then the supplementary affidavit, he would then refer to it to say the reason why I had asserted such a right was because of this facts that are now being averred in this affidavit and or statement, Chairperson.
Let's leave it there. I do not understand you. Let's leave it there. Mr. Matlala, do you want Ms. Sildo to repeat a question, or are you in a position to go ahead and respond?
No, it's okay, I can go ahead.
Thank you.
Chair, before we do, I think perhaps in fairness to Mr. Matlala, we should consider the contents of his paragraph 17 in the original statement, regarding this loan and the loan agreement. And in that paragraph, he states, I'm of the view that I may incriminate myself by answering questions related to this loan agreement, as I believe it forms part of the Medicare criminal matter which is pending before court. It's just that my reading of paragraph 76 and 78 don't tie back to the answer given in there, and instead they speak mainly of the right to supplement.
Yes,
which doesn't answer the chair's question. But
Which is what caused me to raise the question.
To bring to your attention.
But thank you for
Thank you
for that, Mr. Yes, Mr. Madlanga.
So then you have read your paragraph 76 to 78 of your affidavit into the record to supplement your original response to paragraph 2.3.4. That then would take us to 2.3.5. And at the time, 2.3.5 called on you to speak to your appearance at the ad hoc committee and inquired whether or not you had ever been induced, threatened, or influenced to give false evidence. And if so, that you provide the details of who induced or threatened you to give false testimony, when, how, and for what purpose. You respond to that specific question in the affidavit at page 16, starting from paragraph 79 to 83.
I am not responding to this question for the following reasons. When I attended the ad hoc committee, I was not yet arrested and charged as an accused on the Medicare matter. I was also unaware of the fact that I was a suspect on some of the issues I was questioned on. It has now emerged that I am a suspect in a matter I was then questioned on, and the same are under investigation, as was made clear to me during my questioning by IDEC, and as was later recorded in the statement I made in terms of the provisions of the Section 204 of the CPA. I therefore state categorically that I'm not prepared to answer any question I have previously answered on which I have now been charged or in which I am a suspect. Answering such questions now will violate my rights to a fair trial and my right to silence and my right not to incriminate myself. I have also been made aware of the fact that stand to be accused of having made previous inconsistent statements, and more importantly, that I can be charged with perjury if I deal with any of the ad hoc issues.
If I can just, by way of seeking clarity, you do note that if one has regard to the question posed to you at paragraph 2.3.5, you haven't answered the key question there, whether or not you were induced, threatened, or influenced by anyone. Should I understand you correctly that your position is you cannot answer definitively to that question because any response you give thereto, you run the risk of incriminating yourself?
Yes, Commissioner, you're right.
Including an answer that says, no, I was not induced.
My worry is if I say no or yes, then the next question, let's hypothetically saying I'm saying yes. The next question will be by who and then why. And part of those who and why might somehow end up incriminating myself.
Okay. We will come back to the issue in the fullness of time. Just wanted to get some clarity. If you recall, then moving on at paragraph 2.3.6, you were asked to comment on the recording of your interrogation on December 2024 and May 2025 by witness C or any other police officers who interrogated you after the arrest. You deal with that at page 17 at paragraphs 84 to 86.
I've been provided with copies of any of the recordings of my interrogations, whether the same way in December 2024, May 2025, or thereafter. I have dealt with this issue above. Legal argument will be made on this issue as to why I should not answer any questions relating to these recordings.
When you say this issue has been dealt with above, you mean in the body of this affidavit, where it is suggested, as the affidavit does, from paragraph 41, that you intend to launch a challenge to the seizure of your cell phones, as well as your challenge to... Now, I just see the cell phones. Where you say above, where do you deal with the issue of the recordings? Oh, you do please refer to page 9, paragraph 35. You stated paragraph 35, I have learned as a result of information obtained from the commission that the subs have obtained a number of statements from me in violation of my constitutional rights contained in section 35. And then you reference certain recordings. Is that what you mean?
Yes.
So, if then I reread your paragraphs 84 to 85.
Maybe, Mr. Law.
Yes.
The paragraph 35 is about statements, but if you go back, paragraph 32 and 33, that's where he speaks of recordings. So he distinguishes, Mr. Matala distinguishes recordings and statements.
Yes, at 32 he says, I only learned later that the interrogation of me and my responses were electronically recorded at the time.
Yes.
Do you see where Commissioner Baloyi is directing you to?
Paragraph 32.
Paragraph 32 of the
Yes,
same document
yes,
we are looking
yes.
at page 8. And you say this recording and a transcript thereof was made available to my legal team after it was requested from the commission. So I'm saying, regard being heard to what you state at paragraphs 32 to 36, that's the basis on which you say you've dealt with the issue above at paragraph 85, and that legal argument will be made on the issue as to why I should not answer any questions relating to these recordings. You state that at your paragraph 86.
Yes.
So your response to paragraph 2.3.6, then, that to clarify, is dependent on the determination by the commissioners and the chair as regards your claim, your suggestion that your rights were violated as set out in paragraphs 32 to 38. You will not answer until the question of the suggested violation of your constitutional rights is determined by the commissioners.
Yes, but not only that, Commissioner. Also because those recordings, it has been made clear in court that they are currently under investigation. So we do not know which part of the recordings are under investigation. So I cannot recklessly just answer a specific question, not knowing whether is it the one that is under investigation or not.
Perhaps if you could say slightly more, under investigation by who?
This was said in court, so I will assume that it is the same investigating officers that are investigating my current case that I'm attending in the Johannesburg High Court.
So they are also investigating these recordings?
Yes.
Could we request, perhaps, to your legal representatives to obtain that portion of the transcript?
Of course, yes.
In court, because I'm not sure I understand what you mean by the claim that the recordings are under investigation. So perhaps if we get the transcripts, I might gain a better understanding.
It's okay, we'll get the transcripts, but also during the disclosure, it was during the pre-trial actually. So when it was during the disclosure of the docket, and then we've noticed that there were no recordings there, and then my counsel requested for those recordings, and then the state advocate said no, they cannot issue us those recordings because they are a separate matter, they are under investigation. But as you said, we'll get the transcripts and then it will explain everything.
And I think just so we don't talk past one another, we would appreciate those transcripts by tomorrow, so that when we resume tomorrow, we know what the actual position is and how we engage with you on this matter.
That will be very hard for me to promise that I can be in possession of those things by tomorrow. Because, as you know, I don't have access to any. When I leave here, I'm going straight to CMAX, so I won't be able to make any telephone calls, but I will ask that after you adjourn here, then I at least consult with my legal counsel, and then I will ask them to get that on my behalf.
Hence, I specified that I think the request is more to your legal team through you, because I appreciate your position, but I would like to believe that your legal representatives are in a position to obtain the relevant transcripts that assist you in this regard and assist the Commission to understand how to deal with the matter of the recordings.
Yes, but also I would suggest, please, let it not be something that will be required the first thing in the morning, because obviously if you look at time now, they are going to request them tomorrow morning, maybe around 11, 12, then we'll be in possession of those transcripts.
Let me quickly raise a matter of clarity, Ms. Silo. If I did not misunderstand you, I thought you said something about the Commission making a decision on the question of the lawfulness or otherwise of the manner in which the contested evidence was obtained. I'm sorry. Or did I misunderstand you?
No, it's not. I don't say that. I say
Okay.
in his affidavit,
Yes,
he
okay.
suggests that is an
Okay.
issue he's going to raise before yourselves.
Okay.
Yes.
Let me tell you my understanding. You'll correct me if I'm wrong. My understanding was that the decision that he says he's seeking is a decision that will be made by the court on the lawfulness or otherwise of the manner in which the evidence was obtained. And with us, he's then saying, until that has happened, the Commission should be barred altogether to traverse that terrain. So a decision on the lawfulness or otherwise is not one that should be made by the Commission.
Indeed, Chair, I agree
All
with
right.
you. I was
Okay,
reading from
okay.
his affidavit, which is what I had understood.
Yes.
Him to suggest in the affidavit, but I'll hasten to add that this is part of the legal argument and the points raised in limine
Yes,
that I understand perhaps are still to be argued before yourselves. So I would park that issue.
Okay.
But he had the affidavit seems to suggest that it's a legal argument to be made to yourselves. And there,
All right, okay.
Chair, you will see at paragraph 40, it says full legal argument will be made to the Commission on this issue.
Maybe we should not open that door. We should
Yes.
wait to hear if anybody will still raise that issue, because we are hearing the evidence now.
Indeed,
So
Chair.
maybe who knows? Maybe nobody will go back to that now that we are hearing the evidence. And Ms. Missy said what will be raised will be the question of the privilege.
And
Yes.
what I sought to establish here
Yes.
is the basis, because it's not articulated in the papers.
Yes.
And that's when Mr. Matala raises the question of the recordings being under investigation. So that's what I was trying to tease
Okay,
out,
all right.
to understand who's investigating and where he learned that from.
All right. Yes, Ms. Missy?
If I may, Chairperson, we wanted to address the issue with regards to the practicality of getting those transcripts. Because what would happen is that the attorneys would have to put in a request from the transcribers, as I'm instructed, to obtain that recording from the courts. I forgot what the title is to the individual who does the recordings, and then obtain it, at which point would then get access to it. So to say that we'd have it by 12 o'clock tomorrow, perhaps it would be overambitious of us to assume that it's even practically possible. And if we make that undertaking, then it comes back and it may seem as if we're trying to frustrate the process, but practically it doesn't seem possible that we'd have it tomorrow. They are obtainable, it's just a matter of the
Yeah,
timeline.
The timing, yeah. Unless things have improved significantly from the time I was last in practice, I think I agree with Ms. Missy on the practicalities.
I'm willing to accept that. I'm going to challenge her on that, except then there is a gap in the logic that is set out in the affidavit. So perhaps in the course of argument, we might be assisted with more facts to support what is set out in his paragraphs 84 to 86.
Thank you, Mr. Law.
Thank you, Chair.
Chairperson, if I might make a suggestion that would try and aid and or assist the commission in moving forward whilst we wait for that recording, because there's an attorney of record who was present at those proceedings, would it be of any use for him to address that particular point, because he's heard what was said in the ruling or rather judgment made with regards to that? If it would be of any use, we perhaps could assist in this.
I don't think so, because this is a matter of evidence, and Ms. Silo is engaging Mr. Matlala at the level of testimony by Mr. Matlala.
The only issue I seek to establish, and I think it was triggered by Mr. Matala's response, that the recordings are a subject of an investigation. So that's the only clarity I seek. Who is investigating? What does that mean, that they are subject of investigating, and who is investigating? And that is because when I engage Mr. Matala on these issues, I will seek to persuade the commission that to the extent that they may be under investigation, that does not preclude Mr. Matala from speaking on these matters, because it's the recordings, according to him, that are under investigation. It's not him per se who's under investigation. So I'll leave it there for the moment, Chair. When we come back, we perhaps will get better insight.
Mr. Maybe before you then move on, now that we seem to be agreed that we won't have the transcript anytime soon, then maybe let me ask my clarification question. Mr. Matala, the investigation that you speak of into these recordings, is it by the state or by your legal representatives?
The investigation?
Yeah, you said that there's an investigation about these tapes or these recordals of you. Is it an investigation by the state or by your legal team?
By the state.
Is it by the state?
Yes.
And what in particular is being investigated about them? What was said is going to be investigated?
That is something that I don't know, but what I know is they just said that whatever has been I've mentioned in those recordings, for those things I'm being investigated. So I cannot tell what is it exactly what they're investigating there.
Okay, all right, thank you. And then lastly, at that paragraph 84, Ms. Silla, it's either a word is missing or a word that is there shouldn't be there. 84 reads, I have been provided with copies of any recordings of my interrogation, whether same in December, May.
I think of any other words that shouldn't.
Have you been provided with recordings?
Yes.
You have? Okay, so we must take out, I have been provided with copies of the recordings. That's how it should read. Thank you.
Thank you, Commissioner. That then will take us to your paragraphs 87 and 88. You are responding to paragraph 2.4 of the Regulation 10.6 notice, which required you to speak to the nature and extent of your relationship with the EMPD, including individuals employed therein, including agreements actual or negotiated with individuals within the EMPD, donation of vehicles and installation of use of vehicles fitted with blue lights, in particular who was involved, what the plan was, what became of the plan, and ultimately the use of vehicles fitted with blue lights and the use of peace officer cards. That's what was asked of you. You deal with that at page 17, paragraphs 87 and 88. If you could read those.
I have indicated above that I do not wish to deal with or answer any questions on this issue of EMPD. I refer to what I have stated above and the statement I attach here to deposed to by Ntabise Nkodelia Kabeng.
And for the record, that affidavit of Ntabise Nkodelia appears at page 20 of that same file, your VMSA 1, correct?
Yes, that's correct.
And just to confirm, again for the record, this affidavit of Ntabiseng Cordelia speaks to the issue of use of blue lights only.
Yes.
Now, the question posed to you was at paragraph 2.4 was actually a compound question. There were other issues that are unrelated to the issue of the blue lights that you were required to speak to, but once again, you have failed to.
Can I comment on that?
Yes, please.
Yeah, it's not only the fitting of blue lights, it's any involvement with the EMPD, because I said before last week Monday, maybe that's why it's not on this affidavit, that there are people who are currently facing criminal charges for not only the blue lights, it's peace officer cards and blue lights, and I think the donation. And as a result, also my name has been mentioned there. I heard the spokesperson of SAPS mentioning my name there.
So, in regard to these other matters, are you suggesting you are an accused or a suspect because you had your name mentioned? Are you able
Not
to,
an
to
accused.
clarify?
Not an accused. I will say a suspect or a person of interest.
And as a matter of interest, in all these other cases besides the blue lights, which you have explained why you can't address, why do you consider yourself a suspect?
Like I said, there are people already who have been charged with those issues that you just mentioned.
And those people don't include you. So why do you suspect you're a suspect?
The investigation is mentioning my name.
Okay. We shall revert in time.
Maybe just to get confirmation, Ms. Kabeng says the investigation is by iPad. You confirm that?
Yes.
That she was interviewed by iPad and they told her they're investigating.
Yes, I confirm that.
Thank you.
We then go to your paragraph 88, still at paragraph 89, still at your affidavit, starting at page 17, and there you are dealing with the contents of paragraph 2.5. And from paragraph 88, you then deal with your relationship with 4 other people. So if you could read the name of the person you, whose relationship you speak of, and then you deal with the contents of the paragraph immediately following the person's name.
I will start with Jotham Musibi.
Yes.
I knew Jotham Musibi purely as a person to whom I rendered security services. I never had business with him. I know Ignatius Motagati, Andrew Boy Mutetwa, and Katiso Molefe purely by virtue of the fact that I came across them and were introduced to them on occasions by Jotham Musibi, to whom I rendered security services. I never had any business dealings with them. I never sat around talking to them. I do not know any about their personal life or the business they are involved in.
Now, before you deal with the next person, at 89, you say you knew Mr. Msibi purely as a person to whom you rendered security services. I never had business with him. What do you mean by that last line, that you never had any business with him or businesses?
I will say I never had I attempted, yes, to do business with him, but it never materialized. So I never had any business without rendering security services with him.
And then while you are on that, what businesses did you attempt to have with him that did not materialize?
To purchase a private jet.
Yes. Any other?
No, it's only that.
Only that one.
Yes.
Were you then ever involved in any of his business dealings?
No.
Okay. Thank you. You then, from paragraph 91, at paragraph 91, deal with your relationship with the next person. If you could identify them and then read your paragraph 91 into the record.
Mike van Wyk. He was my business partner and is a witness in the Medicare matter. I am therefore exercising my constitutional right as an accused not to respond to or answer any questions pertaining to him or our relationship.
Now, he was your partner in the Medicare matter, and you say you are exercising your constitutional rights. I just want to understand, is this an exercise of constitutional rights in respect of any and all affairs of Medicare? Or is it only in respect of the SAPS contract for which you are currently facing charges?
Yes, only the SAPS contract.
Only the SAPS contract. Thank you. You proceed then to deal with the next person, and at paragraph, you identify them and deal with their relationship at paragraph 92, or your relationship with them.
Baron Mohoti, I have answered this aspect when I gave evidence.
So in effect, you're saying you've got nothing further to add to what you've already stated?
Yes.
Okay. Then lastly, I think at paragraphs 93 and 94, it's the last person.
Angwani Mogen Maumela and Suleiman Karim. My legal team is in the process of collating evidence in respect of the said persons which will enable me to move fully with awareness of an explanation of my rights, answer questions about them. I thus reserve my right to supplement this affidavit. I reserve my right to provide the Commission with any further and supplementary sworn statements necessary in these proceedings.
Can I just clarify paragraph 93? You say your legal team, quote, is in the process of collating evidence in respect of these persons being Mr. Hlangwani Morgan Maumela and Mr. Suleiman Karim, which will enable you to more fully, with awareness of and an explanation of your rights, answer questions about them, end of quote. Can you say that in simpler English? What do you mean? I understand that they're in the process of collating evidence in respect of these persons, but I'm not sure I understand the remainder of that sentence. Are you able to assist? What do you mean that the evidence that they are collating will enable you to more fully, with awareness of and an explanation of your rights, answer questions about them?
I think this is a typing error.
Okay. So I'm not that bad. Let's try and correct it. What did you wish to express?
Documents that will support that I do not wish to answer these questions because of self-incrimination. This morning I have managed to get a document that I already supplied to my legal counsel.
I'm not sure I understand. It's a very cryptic answer you've just given, so I'm not sure I understand.
What I'm trying to explain to you is,
Yes.
like the first sentence saying that I'm in the process of collating evidence.
Yes.
So maybe I was supposed to say documents that will prove that I'm a suspect and I'm being under investigation together with Mr. Maumela and also with Suleiman Karim.
Okay. So, okay, I think I understand. So then you say your legal team is in the process actually of collecting documents that will demonstrate and prove that you are a suspect. I take it in some alleged criminal wrongdoing together with, not together, with Mr. Maumela and or Mr. Karim. Is my understanding correct?
With Mr. Maumela, Chairperson, sorry, Commissioner, if you can remember, last week I already touched on the Suleiman matter, and then you asked that I should bring an unsigned, what is it? An unsigned
Loan agreement?
Loan agreement.
Yes.
So this is what I had that loan agreement, but I couldn't just find it. So what I had is only the document in relation with Mr. Maumela.
Okay, now, so you say that those documents will prove you a suspect. A suspect in what? Or which cases?
Suspect in, I think this money laundering, I think.
And that is in relation to both the persons identified
No,
there?
only with Maumela.
Or with Mr. Maumela? And when can we expect these documents to be submitted? Because you say that your legal team is in the process of collating them.
They are already in possession of those documents.
Okay. I take it that they're in possession of the documents with a view to share with the Commission.
They will advise on that because they are under investigation. I don't know.
Or you just gave the documents to your
Chairperson, if I may be allowed to address the Commission in relation to that.
Yeah.
We couldn't just take it off word that he says that he's a suspect, and we needed to confirm before he would be able to make such an allegation of vermin before the Commission. And so he had to look for the document, which unfortunately, as I stated, he was unable to give it to us, the team yesterday. This morning he did give us the document, and it places us in a position where we can give, or rather he can make that statement on affidavit that he is a suspect and would be claiming his rights to privilege in terms of section 3(4). Sorry.
Now,
We'd need to supplement, if I may, would need to supplement his affidavit so that he's able to make those averments and give you the correct facts.
so is it the intention of Mr. Matlala and or his legal representatives to share the actual document that demonstrates he's a suspect?
Ms. Missy?
Chairperson, the issue that we're having is that we haven't properly looked at the document to determine whether, to what extent he can claim his right to a privilege. So provisionally, I would say yes, provided that we get a timeline in which we are informed that the supplementary affidavit needs to be in at a particular time, and then it allows us to look into the document and determine there isn't everything that's privileged that disallows us to hand it over to the Commission.
Is there any problem sharing it with the evidence leaders right away?
Chairperson, I have not looked at it in detail. It's a document that immediately after we had engaged, we came down, he handed it over to me. I quickly glanced over it, so I can't answer that question definitively.
Is it a privileged document? Because if it is not, I would not understand why it cannot be shared immediately.
Chairperson, I suppose if you have to ask if it is a privileged document, I do not believe so, because the investigators would have a copy of it.
Then it should just be shared with the evidence leaders. So as you look whether there is a basis for claiming privilege, the evidence leaders will be looking at the document for themselves as well.
Noted. Share then on those bases, we should be able to share it.
It will be shared this afternoon still.
That's correct.
Thank you.
Thank you, Chair. Thank you, Advocate Missy. I think it should, because as things happen in the Commission, documents become available and they are added to the exhibit bundle. So too, regardless of their source, so too shall this one. And this document is important. As a result, I'll have to park the issue I intended to raise in respect of 93. It's important because it would appear, Mr. Matala, that you have adopted this posture regarding almost all the issues or the persons you've been asked about. If we go then, before I forget, that is the conclusion of the supplementation of his statement. You confirm that that paragraph 94 is the end of your affidavit.
Yes, I confirm.
So then you have given your supplementation. So then,
Ms. Silo,
yes.
I don't want to get ahead of you because it may be that you're still coming there. When I looked at 2.2 of the 10.6 notice read with Schedule 1, according to my reading, item 5, the person who appears as number 5, there's still not answer to the question in 2.2. Because 2.2 said, explain your history and or relationship, direct or indirect, with the listed law enforcement officials in Schedule A. And then when you go to Schedule A, it lists 28 people.
yes.
But on my reading of both affidavits, I thought it was an omission in the first one, and the second one was supposed to supplement. But I don't see in the second one where it deals with the name in item 5, unless I've missed it.
No, Commissioner, you haven't. Mr. Matala, you understand we referred to Schedule 1 and the Regulation 10.6 notice, correct?
Okay.
We discussed the people listed in that document at page 7. And you will recall that in your original statement, when you, from page 12, you then dealt with, at paragraph 14, you dealt with a cluster of persons, 13 of them, from General Masemola to Major General Temba, about whom you said you will not be able to say anything regarding your relationship with them because they are your co-accused in the Medicare matter.
Okay.
From paragraph 15, you then dealt with some of the remaining persons on that list. You see that?
Yeah.
And there you dealt with Minister Mkunu, Patlane, General Patlane, General Mkwanazi, General Fani, and General Khan. You see that?
Yes, I do.
Now, in your supplementary statement, you then deal, or you purported to deal with the remainder of the persons you had not spoken of. And in this regard, as we looked at your statement, you, at paragraph 71, page 14, you once again deal with Minister Mkunu. You deal with former Minister Bekitele. You deal with, once again, with General Patlane at 15. You once again deal with General Mkwanazi. And you deal, followed by General Fani and General Koza. This is the affidavit we've just looked at. General Khan. It did sound. There has to be an explanation, Chair, somewhere on my papers there must be a Koza. I apologize for that, General Khan. So you deal with those at your paragraph 71, starting at page 14 of the affidavit. You see that?
Yes, I do.
Then we went further in your affidavit at page 18 from, page 17, from paragraph 89, you deal with Mr. Msibi, the late. You deal with Mr. Van Veek, once again, Mr. Mkhotsi, and then you deal with Messrs. Hangwani Maumela and Mr. Suleiman, and Suleiman Karim.
Yes, I see that.
Now you confirm, if you go back to your annex Schedule A, that item 5 required you to speak about your relationship with Lieutenant General Shadrach Sibia. And the question posed by Commissioner Kumalo is that even in your supplementary statement, quote unquote, you have failed once again to deal with your relationship with General Sibia. You note that?
Yes, I do.
I think then perhaps this might be your opportunity to explain to the commissioners why you elected, notwithstanding that you were given a further opportunity to deal with that relationship in the terms as requested of you.
Oh, firstly, if we can remember, Commissioner, you asked me about, this goes to General Sibia, but I need to take you back. You asked me about my interactions with General Mkonazi. What was it that was discussed during the meeting? And I only told you about the Medicare tender and the warrant. So, and I said some of the things I could not talk about them because I wouldn't want to prematurely disclose my defense strategy. Because if you go back, and now I mentioned about General Sibia, and the very same recordings that I was talking about, his name has been mentioned there. And I said, those recordings are under investigation, and I do not know what actually are they investigating me about in those recordings. So I did not say anything about him because I did not want to somehow end up incriminating myself.
I think, Mr. Matala, the question is, what is your relationship with this person? So it has nothing to do with offenses that are under investigation and the possibility of self-incrimination. You are being asked to explain your history and or relationship. Take Mr. Van Veek, for example. You've set out what your history and relationship is with him. Then you say, because he's a witness in the Medicare matter, you won't say anything further. But in relation to General Sibia, you don't even say you know him. You don't even say you have a history with him.
Okay.
And that is separate from whatever issues are being investigated and may be the subject of criminal proceedings. So I would expect you to please answer the question, what is your history and relationship with General Sibia? And then at a stage where you need to assert your privilege, you may do so. But I cannot accept that you are not even able to say, I know the person.
I understand, Commissioner. So I will say I know him because of at some point I went to his office to make a complaint about the occupation of the lease agreement that I had with Public Works. So that is the first time that I got to know of him.
The what of the lease?
The lease agreement, I had a lease with Public Works for the hospital that is situated inside SAPS College, which is in Pretoria West. So, and then I couldn't occupy that hospital. So that was my first time that I went to him to complain about that.
Perhaps to assist you, please let's go to the Regulation 10.6 itself, because specific questions are posted there in respect of each individual that is listed in Schedule A. So if you could consider all the questions set out in subparagraphs 2.2.1 to 2.2.7, can we invite you to answer each one in relation specifically to General Sibia? That might help Commissioner
Sorry,
Kumalo.
Commissioner, can you please clarify that again?
Please, let's go to the Regulation 10.6 in the same file that contains your statement. The first document should be the Regulation 10.6 notice.
Yes.
And if we go to page 3 of that file, At sub 2.2, it reads, explain your history and or relationship, direct or indirect, with the listed law enforcement officials in Schedule A attached hereto. In your response, you are required to provide the following information, and then it is set out in further subs 1 to 7 at page 4.
May I make this request, Mr. Law? Can you please read all those sub-paragraphs, but instead of individuals or officials, specifically refer in each instance to General Sibia?
I shall do so, Chair.
And then, so you refer to 2.2.1, we wait for an answer.
I shall do so,
all
Chair.
the way down. Thank you.
Thank you. So, but you have reacquainted yourself with paragraph 2.2. You understand what it requires of you.
Of course.
Yes. So then, back to Commissioner Kumalo's question, we are talking about your relationship now specifically with General Sibia, and we are going to consider each question in turn and have you speak and respond thereto, but confining your response only to your relationship with General Sibia. You understand?
I do.
Then the first question would be at paragraph 2.2.1, and then in this context would read, when and how did you meet General Sibia? If introduction was a third party, please provide the details of such a party.
When our 2023 or 20, we still on General Sibia, right?
Yes, only.
Yes. It was in January, our 2023 or 2024, I don't remember well.
Okay.
And then by how, I already explained how I met him.
No, you haven't. You say you met him when you went to raise the issue of the lease agreement regarding the hospital at the subs college. That doesn't speak to the how. So I'm sure if I tried to go to that office, they won't grant me access. How did you gain access there?
Okay.
How did you secure that meeting to get the opportunity to put your gripe to him? Why did he entertain your visit? That's the kind of detail required. So if you could help us with that.
Yes, it's because I sent him an email.
Okay.
And then requested for a meeting. And his email address was given to me by Sergeant Ngosi.
Yes.
That's, I think that will answer by a third party who made the introduction.
So it was Sergeant Ngosi who made the introductions?
Yes.
Okay. The second then is at 2.2.2, the nature or description of your relationship with General Sibia.
I do not have a relationship with him.
Maybe not now, but let's say from the date you met him until the date of your arrest. What was the nature of your relationship with him? The description, nature or description of your relationship?
I do not know how to answer this question, Commissioner. You say nature.
Were you friends?
No.
So your engagements with him, what were they? Were you engaging with him as a policeman, as what?
The engagement, hence I said, is something which is under investigation, which I cannot. Yes, there are engagements, but it's something that is under investigation, and partly some charges that I'm currently facing. So for me to explain that to you, I have to go deep in and then explain the nature of the charges that I'm currently facing that involves him.
Let me ask you this. Are you not able to say, these are the examples of the engagements I had with him? With these ones, there are no issues. But this one, I know that there's an investigation, so I assert my privilege. I would have a difficulty if you said, even when you met him at his office, to lay charges or to complain about service delivery. You're not going to tell us about it.
But that I've already done it.
Now, you mentioned one incident when you met with him to discuss the public works issue.
Yes.
So that was one.
Yeah, of
And
course.
the question I asked you was, from that moment until the date of your arrest, what was the nature and description of your relationship?
That's something that I cannot go into because it's under investigation. I cannot go into that.
Did you, after you had met him for the first time, did the two of you socialize? Maybe meet at ceremonies, functions?
You mean the first time?
Did after you had met him for the first time? After?
Yes, I met him.
Did you socialize?
Socialize meaning
meet at
meeting at a social
ceremonies,
gathering.
meet
Yeah.
at ceremonies, functions?
Yes, yes.
Okay. And what sort of gatherings or ceremonies?
It was an engagement party, I think.
Whose engagement?
I don't know whether it's his daughter or his son. I'm not sure about that. But it's between the two. I'm not sure whether it was the daughter or the son.
All right, thank you.
Thank you, Commissioners. You say, I will say it is under investigation, and of course I speak subject to your correction. You can't talk about your relationship with General Sibiya because what is under investigation exactly? Is it your relationship with General Sibiya that is under investigation?
Is the contents of what is in the recordings regarding General Sibiya, and also is in relation with the Medicare tender.
So what is under investigation insofar as your relationship with General Sibiya is concerned is regarding the Medicare tender?
Yes, that's correct.
And anything else?
Like the contents that are in the recordings.
What does that mean, Mr. Madlanga?
Chairperson, for me to explain that, I have to obviously now speak about what is in the content of those recordings.
You see, what I'm trying to understand is you are asserting a right, right? And the right you seek to assert is the right not to self-incriminate. Now, logic dictates that you can only self-incriminate in a specific offense. Do you understand what I'm saying, at least?
I hear you.
Okay. Now, what you seek to do, you say you can't talk of a relationship generally with this particular person because there is a risk you will incriminate yourself. That then raises the next question, incriminate yourself in what? You must be able to articulate that for the commissioners to accept that, yes, indeed, you do face such a risk. So you're going to have to articulate they're going to have to explain exactly what the offense is.
The offense...
Perhaps let me just explain where Ms. Silo is coming from. There is a decision by the Constitutional Court, and sitting here in a legal context, we are bound by those decisions. There is a decision by the Constitutional Court that says if someone is asserting the privilege that you are asserting, what they say must be within clearly defined contours or parameters. They cannot just in general say, I'm asserting my privilege against self-incrimination. So it's on that basis or at that level that Ms. Silo is engaging you. Do you follow that? So you cannot just say, because issues relating to Mr. Or General Sibiya somehow relate to the Medicare 24 contract, I'm not willing to answer any question relating to that because I might incriminate myself. That may not fall within what the Constitutional Court prescribed. So it's on that basis that Ms. Silo is engaging you. Are you in a position to respond, or do you want Ms. Silo to repeat the question?
So saying that it's because of the Medicare tender, it does not justify why I cannot comment on that. So I should explain, is fraud, is money laundering. So I do not know how I should explain that. I don't know.
Okay, let's try it this way. You are facing a criminal charge in respect of Medicare 24 tender.
Yes.
General Sibia is not.
Yes.
What bearing does your relationship with General Sibia have on that charge you are facing when he's not your co-accused?
He's not my co-accused, but
Yes.
He's been investigated
By who?
by IDEC,
In what case? For what crime? What offense?
the Medicare tender.
And what is the proof of that when he is already not part of the litany of accused who are now being charged for the Medicare tender? So you have about these 14, 15 people who are already facing criminal charges. Now you say by IDEC, initiated by IDEC, and you say he is still under investigation. On what basis do you so say? Because one would have expected that he formed part of this cohort of accused persons, which he doesn't.
Yes, I do not know why he's not part of the...
Then how do you know he's under investigation?
Because I've been questioned about him, and also I have made a statement under Section 204 when I was being questioned about him.
You were questioned about him in respect of Medicare 24?
Yes.
Okay. I'll accept that. But what does that have to do with the fact that he's your friend? I'm sure you were questioned, and I suggest to you, about certain conduct, his conduct. Was that not the extent of the questioning?
Of course.
So that conduct, you don't need to be friends for that conduct to raise questions and be subjected to investigation. We are not discussing his conduct. We are discussing your relationship with him. Why can't you comment on that without necessarily saying anything about his conduct, which you suggest IDEC is investigating?
Commissioner, I've already commented on that. I don't know whether you want me to say, I told you he was not my friend. He's not my friend. But there is an investigation that is going on. So I do not know what is it that you say I cannot comment on. Unless now, if you want me to explain what is it exactly that IDEC is investigating him for.
No, that's not my question, because you want that to be my question. I'm staying away from that question. I do not accept, just for the record, that he's under investigation, because you haven't even proven that he's under investigation. Your say-so is not enough. It's not your get-out-of-jail card to refuse to answer a question simply because you suggest somebody else, or you suggest that there is an investigation, and there is not a morsel of proof before us that there is such an investigation. It is no answer, but that's not what I'm asking you. I'm asking you about your relationship with the man, and that you describe the relationship. Is it a long-term relationship initiated on that particular date when you went to complain about the hospital, the SAPS hospital? Does it sustain? Has it broken down? Was it very close? Was it a business relationship? I'm giving you. And you see, so far, I haven't even gotten anywhere close to what IDEC is investigating him for. And I'm demonstrating that you can answer that question without reference to what you claim IDEC is investigating him for.
Okay, then which question do you want me to answer?
Please describe in your own words the relationship you have with General Sibia you had, and if it has since changed, when it changed, and the one you currently maintain with him.
The relationship that I had with him, it was not like a friendship relationship.
Okay. Well, if it was not like something, it has to be like another. What was it like?
Now you're pushing me to say something that I do not know what I will say, because he was not a friend, yes. And for me to go further, is the only way to do that then is to go now into the contents of the investigation, which I do not want to tap in that territory.
Okay, let's...
Was he an acquaintance?
is someone that I knew.
Thank you, Chair. Perhaps then let's continue. It might become clearer in time for the commissioners, the nature of relationship. Staying then with the regulation 10.6 at 2.2.3, page 3, that's where I'm reading. The 10.6 required you, in respect of General Sibia, to explain the nature, extent, and frequency of your communications with him.
Communications, it was maybe once when I went to his office.
Okay. And by communications, direct or otherwise? Have you communicated with him directly, and have you communicated with him indirectly? When we talk about indirectly, please explain the method of communication you conducted then.
Directly, yes, through, I sent him an email.
Yes.
That was the first time. I've never called him directly. So I only spoke with him, I think, I'll say 3 or 4 months. I'm just saying on top of my head, I cannot remember well. Maybe I'll say 3 or 4 months after I first met him. And then the communication then was through a third party, the very same Sergeant Nkosi.
And how frequent was that communication?
Frequent, plus minus 3 or 4 times.
And what was the communication about?
Let's leave it there because that is part of the investigation.
Is the engagement party you attended of his daughter or son, are you seriously suggesting it's part of IDEX investigation?
Yes, it is.
In what manner? As to who engaged who and why, or why?
I think I'll have to discuss with my legal counsel because I'm in possession of my 204 statement. The only way for you to understand that is for you to see the statement, but it is.
I think then it would help for the commissioners to understand the basis on which you seek to assert this right? Because the attitude you are adopting is you cannot ask me about General Sibia because IDEC is investigating something somewhere.
But Commissioner, fairly speaking, I have to go to court and account on this, so I cannot now ventilate anything that is to do with him, especially something that is already being under investigation. I do not know even whether he will be charged or not. So chances are he might not even be charged. I don't know that. But currently myself, I'm charged, and I have to go to court and account for these things. So I don't think it's fair for me now to speak about something which I'm not sure at the end of the day whether I'll have to account for that or not.
You see, the challenge I have, Mr. Matala, is I think you conflate yourself with General Sibia. You are not General Sibia. You are facing charges for your conduct. And we haven't done anything to even stray into that discussion. We're talking about something separate, which is your relationship with yet a third party who's not charged with you. So I don't understand, in the current criminal case that you are facing, how you'll be called to account for your relationships with, including General Sibia. How does that come into play?
It actually does.
How?
I don't know how because I'm not an investigator.
Okay, then I'll tell you that it doesn't. You cannot even, I won't even say prove, it's too high a threshold. You cannot even persuade the commissioners that it is relevant for purposes of the current criminal case you are facing. You are not able to. You accept that?
I do not accept that.
Okay, then if you don't accept that, then demonstrate to these commissioners that relationship is relevant to the charges you currently are facing.
I think I've just said it that the only way for me to demonstrate that is for me to now to get right inside the cracks of the matter, which is something that I cannot do.
Then I'll put this proposition to you. that you don't want to talk about the nature, extent, frequency of your communications with General Sibia, because if you do, you are at risk of incriminating yourself in some offense, because by their very nature, they would be breaching the law. That's my proposition to you. What's your response?
I cannot argue with you on that.
Okay.
That's how you see it.
Then,
Sorry, before you move
Yes.
on, Mr. Matlala, in describing the nature of the communications with General Sibia, you have a number of options, and without getting into the detail of it, and I don't intend to repeat what Ms. Silla has said to you, because ultimately the Commission must be satisfied that you have correctly asserted the privilege against self-incrimination. And for us to do that, we need to know what it is that you avoided talking to, not in general terms, general broad terms, but specifically. Having said that, when I say you have a number of options, I can put this to you as an example. You have had interactions with General Sibia. We know you sent an email, you went to the office, and you do say it had to do with the lease. I think it's competent to ask you, have you had any interactions with him about the Medicare contract, still at general terms? And if you're asked what exactly, you can say, I wanted help to resolve the lease issue. You testified in the ad hoc committee, for example. You said you interacted with him about the kidnappings of, I think, Mr. Bushocha and Mr. Khale. That has nothing to do with your Medicare contract. And if you don't speak to that, then you are not being frank with us. If you don't say, well, other things that have nothing to do with the Medicare contract I've dealt with him, then you're not being frank with us. The chairperson said to you, asked you, have you socialized with him? And it had to be put, it had to be dragged to you, in my opinion, for you to say, yeah, we had an engagement. So there are topics that demonstrate or would explain and say something about your interactions with General Sibia, and they have nothing to do with Medicare. And there's no basis or valid basis for you not to speak to those when you're asked to explain your interactions with General Sibia.
I think also what Commissioner Baloyi is referring to, I think we have had sight of the ad hoc committee transcript. If I'm not mistaken, I think it's in that transcript where you say, in fact, you contradict what General Sibia said before us here. You say you attended the engagement function, and that you did not go there just to pick up your wife, which is what General Sibia told us. You say you attended that, and as I understand it, you attended as an invitee, and you were there for a period much longer than just going there to pick up your wife. So I'm raising that in support of what Commissioner Baloyi is saying, which is there is a lot you can talk about, and I do not see how it's incriminating for you to tell us that you went to the engagement party and also to contradict General Sibia on what he himself said about your attendance there.
Thank you, Chairperson. Chairperson, it's not only the Medicare tender. Like I said before, it's also the contents of the recordings which are also putting me at the risk of self-incrimination. So I do not know how the approach of, I cannot tell now as I sit here what is the approach of the investigation. I do not know that. So when I testified in the ad hoc committee, by then I was not yet charged or even being under investigation. So now it's a different thing now. I'm charged and I'm also under investigation.
You have only two bases on which you assert that privilege. You are either an accused or you're a suspect. There's no all-encompassing protection or umbrella that you say, well, I know it's being investigated and I don't know which way it will go. That's not what that protection that is given to you is all about. That protection applies if you show that I'm an accused on this issue, this very issue, and so I shouldn't be required to speak to it because I'll self-incriminate. That is the easier part. The other is I'm a suspect. But even there, you have to provide details because, as Ms. Silva says, it's not your say-so. You know, you don't just say, I'm a suspect, and that's the end of it. We are entitled to engage you to establish that indeed you are a suspect. Because if you're a suspect, of course, we have to be careful what we ask you if you are asserting that privilege and how we engage with you. So those are the two topics. That something is in the recordings is not sufficient to invoke that protection for you. You can't simply say, well, it's in the recordings and those recordings are being challenged and I don't know how they are going to use those recordings, therefore I should not be required to answer those questions. I think you can accept that if the privilege is properly invoked, if you rely on it properly, on the correct facts, the commissioners will give it proper regard because we wouldn't want to impinge on your fair trial rights. You can accept that, but the burden is on you to show us that in answer to a particular question will tread into your fair trial rights, and we must respect that. So far, you're speaking in you're dealing with matters in very broad and general terms, and that doesn't avail you. It's not available to you. But more importantly, you are either a suspect, and you have to show why you say you're a suspect in a particular matter, or you're an accused. Those are the only two circumstances. I don't know if you want to comment.
Yes, I wish to, Commissioner. I said I will make sure that I get the transcript from the pre-trial to prove that I'm actually a suspect in those recordings. And I will say again that in those recordings, I did not know to which extent they're going to investigate. So I do not want to be careless by saying something that will later incriminate me. But that is a fact that I am under investigation for those recordings, and then I will prove it by getting those transcripts so that you will know that actually I am a suspect.
Do you accept that we have to have those transcripts presented to us? They must be engaged upon with you. They must be before us. You must look at them. We must engage with them in order for us to agree with you on any item. It's not everything that's in the recording. I take it that you say is untouchable. But even if that's what you're saying, that everything in that recording is untouchable, you do accept, at least I think I understand you, to accept that those recordings would have to be before us, and then to engage with you when you say, that part, if I deal with it, I'm self-incriminating. You accept that?
The recordings, I do not want to deal with them because they are under investigation. What I wanted to do is bring the transcript to show that those recordings are being investigated.
Transcript of the recordings?
I'm sorry, I meant to say the contents of the recordings, yes.
That's what you mean when you say transcript. You mean the contents?
I said I will bring the transcripts to prove that what is in the recordings, I'm actually being investigated for that. So for me to prove that is to bring the transcripts.
Yeah, I'm just trying to clarify the transcript of what?
Of the recordings. No, I'm sorry. I'm sorry. The transcript of the pre-trial where the state advocate mentioned that I am under investigations in regards to those recordings.
Okay. All right, but you've heard me, what I said earlier.
Yes,
that
I did.
We would have to hear as per question or topic. We need to see that indeed, if you are required to answer a question, a specific question relating to that topic, then it does validly raise the self-incrimination defense.
I take that, yes.
Thank you.
Thank you, Chair. Perhaps if we could see if we can quickly work through this list. We now get to sub 2.2.4, which required you to comment on the nature, extent, and frequency of physical meetings and/or gatherings with General Sibia, including when, where, and how these meetings were organized. Provide details of the persons in attendance and as well as the purpose for each such meeting. So if we look at 2.2.4, can you tell the commissioners how frequently you met with General Sibia and under what circumstances?
I will say maybe 3 or 4 times.
Can you deal with each incident as to the purpose of that meeting and how it came about?
The first time I've already mentioned it. And the second time is when I was going to get a feedback of what I was complaining about.
And how did you get that feedback? Where and?
I went to his office also.
Once again?
Yes.
And this was to get feedback on?
The public works lease agreement.
Okay. And who arranged that particular meeting for you?
Sergeant, I think it's Sergeant Ngosi.
Sergeant Ngosi. Do you know, how did Sergeant Ngosi communicate with you that the meeting, he has succeeded in arranging this meeting?
He had my telephone number.
Say that?
He had my phone number.
You still don't tell me how he communicated with you.
I'm saying he called me.
Okay. Now,
And when he called you, did he call to say General Sibia wants to meet with you to give you feedback? Because it's Nkosi that calls you.
Yes.
Is that how it happened? Thank you. You said yes, Mr. Matala.
Yes, yes.
oh, I too had missed the answer, sorry. So that is the second time. Now, the next time?
I think I will confuse the timelines because it's a long time ago, but
Okay.
there was an occasion where he asked me about the Jerry Boshoga, so I do not know whether it was the 3rd or the 4th time. I don't know that.
Now, can you tell us more about that engagement? How it came about and who initiated it?
He initiated it, yes.
Directly with you or through Sergeant Ngosi again?
Like I said before, he never called me even once.
Okay, through who did he do this?
With Sergeant Ngosi.
And what about Jerry Boshoga? Did he want to engage you on?
I think it was after the raid from my house, because the police came to my house and then they said that they were looking for a kidnapped victim.
Okay.
And then later I just don't know, I can't remember when, but at some point I went to him and then that's when he asked me that, what do I know about that?
Oh, you went to him?
Yes,
Is it back at the office now?
yes.
Who helped you to set up that meeting?
I said it was Sergeant Ngosi.
No, the Sergeant Nkosi, remember we stopped counting, and I do accept that it's a long time, so you won't exactly know whether it's the second or third. Sergeant Nkosi organized for you to get the feedback on the lease agreement. That much you said.
Yes.
So now this is yet another meeting, and you didn't want to commit as to whether it's the third or the fourth. This is regarding Mr. Boshoga. You said he initiated it. You said General Sibia initiated it, and you said he did so through Sergeant Nkosi.
Yes, I said.
And you said you went to him
Yes.
at his offices.
Yes.
And so he requested to meet you.
Yes.
What about? Did he explain?
Are we still on?
On Mr. Boshoga, yes?
Yes.
Yes.
Yes. It was about that. He asked me what I know about that.
So then, if I understand your communication channel, he would ask Sergeant Nkosi what you know about that. Sergeant Nkosi would ask you in turn what you know, that General Sibia wants to know what you know about that. Your response would be, no, I don't know much, or I know whatever, and then is that how the communication works?
Oh, no.
Oh, please enlighten me.
He asked him to arrange a meeting, then I went to him,
Okay.
and then that's when he told me.
So he initiated this engagement with you?
Yes.
Do you know in what capacity he did so? Was he investigating this kidnapping, or was it as an interested person, as a relative? Do you have a sense of why he reached out to you on this matter?
Yeah, I think he was, because what he said to me, but I don't know what to make out of that, but he said if he can crack that case, it will help him a lot. So I don't think it was because of he was a relative or something.
Okay. So he initiated this contact for purposes of investigation?
I think so, yes.
Now, if that would be in his official capacity, I take it, as a police officer, I think a senior ranking member of the service.
Yes, he
was. It would be
was.
official.
I don't know how we will justify it to be official, but he just called me as a police officer, so I don't know.
And that's precisely what I'm trying to determine. It's a police officer.
Yes.
You have been questioned about the kidnapping of Mr. Boshoga. I take it was not by him the first time when you say they came to your residence.
Yes, yeah.
So now we know that he subsequently becomes involved in it by requesting a meeting with you, correct?
Yes, that's correct.
Hence my question, did you understand him to be investigating that disappearance of Mr. Boshoga? What was your understanding? What process were you engaging in, seeing as so far you had just met him twice about the lease agreement?
But as a senior police official, maybe he will refer the investigation to someone else. I don't know how it works, but what I know that he called me and then he asked me questions in relation with Mr. Boshoga.
So you don't know whether he was doing that as an investigator into the kidnapping?
I cannot tell that. I don't know.
Okay. And were you able to respond to his questions to satisfy his curiosity?
I think so, yes.
Okay. Now, we would have said that's your third meeting, but you did say that it was some time ago, so now you're no longer so sure. I will just talk about the next contact you had with him. When was the next, and who initiated it, and where, and what about?
Okay, let me say this, because all of his requests to meet him was through Sergeant Nkosi. So from now on, whenever he called me, it's through Sergeant Nkosi.
Okay.
Yes.
So then before you get to my question, if he was an investigator in this Mr. Boshoga's disappearance, shouldn't he have contacted you directly? Isn't that what investigators do? Couldn't he have obtained your number from Mr. Nkosi and say, I, as a general in the police service, I need to talk with Mr. Madlanga for whatever reason, because I'm investigating a kidnapping? Why couldn't he contact you directly?
That I cannot answer. I don't know that.
So you did make the point that all future and past contact with him was initiated through Mr. Nkosi. As a matter of interest, did you ever inquire why or who made Mr. Nkosi the intermediary between the two of you?
I think it's Mr. Nkosi himself who started this thing.
How does he do that?
Because he's the one who gave me his, his email address.
Yes, the first time I can understand, but why couldn't you then have your direct contact with General CB after that, after the initial contact? Why did you always need to work through Sergeant Nkosi?
I do not know that, but that's what was happening. I don't know that.
It never crossed your mind that by now you are on your fourth contact, the one we're going to discuss next, that perhaps your relationship has developed to a point where you can contact each other directly?
Commissioner, when that thing was happening, obviously I wouldn't know by then, but now I will understand why that was happening. But unfortunately, what was happening is something that I cannot speak about. I think I requested that some part of my evidence I will request because I'm under investigation. I'm really under investigation. I'm not making this up. So I asked that maybe if it's possible that I can, some of my testimony can be in private because I cannot risk incriminating myself. That I cannot do.
Does Mr. Bushoka's kidnapping have anything to do with Medicare 24, which we know is the case you are currently facing in
Medicare
court?
24?
Yeah. You have always invoked Medicare 24, and I'm interested to find out now whether Medicare 24 is relevant to the issue of the kidnapping of Mr. Bushoka.
No, it's not.
Okay, so Medicare 24 is out of the way. So what is the basis on which you cannot speak? You say you're under investigation by who and for what?
I'm saying, we're speaking about General CBA now. I think your question is in relation to General CBA. I'm saying I'm being investigated, and then I'm also charged in relation with the Medicare tender and also the recordings that I mentioned.
You hit your mic.
Sorry.
Thank you.
The recordings that I mentioned earlier, that also his name is been mentioned there. So I'm saying this because I know for sure that there is an investigation going on in relation with those recordings, and also I've been questioned about him by IDEC.
IDEC?
Yes.
Okay, perhaps if we look at it this way, what do you, to your understanding, what is General CBA being investigated for? And by who?
Now, for me to do that, obviously I need to disclose the nature of the investigation and my case.
No, that's not. What is he being investigated for?
Yes,
which offense?
Yes, that offense, for me to mention that offense, I'm saying now I have to speak about what I'm trying to avoid.
No, that's very cryptic.
Can I
yes.
try? Mr. Madlanga, you reference to IDEC investigating General Sibia. Is it about, does it relate to Mr. Bushoka? That no, you can answer.
No, I said it does not relate to that.
It doesn't relate to him. Does it relate to the Medicare contract?
Yes, it does.
Okay, thank you.
Thank you, Commissioner. That's the point I made. I said we'll stay off Medicare 24, but you can talk about the kidnapping of Mr. Bushoka that General Sibia investigated, and in the course of investigation, he engaged you. What's that got to do with Medicare 24? Nothing, right?
No, we're not speaking about, it's two things here. So Medicare 24 is a separate thing. So when you called me about Mr. Bushoka, it has nothing to do with Medicare 24. It's something different.
So which means then we can talk about what your engagement regarding the kidnapping of Mr.
Yes,
Bushoka.
of course, we can.
Yes, so let's continue talking about it then. Chair, I'm looking at the time, perhaps a comfort break, I don't know. I appreciate we started late, so I don't think it's appropriate to stop at this juncture, otherwise we'll run into trouble time-wise.
Let's take, what? Let's adjourn and come back at 4:10.
Thank you.
1, 2. All right, we said we would resume at 10 past. It is 10 past. Please make sure your phones are off. Thank you.
Yes,
Thank you,
Mr.
Chair. Oh. Chair, before we get lost in the questioning of Mr. Matlala, I just need to clarify something. The Chair ruled that the document that Mr. Matlala refers to, being as was described regarding, I think, Mr. Hangwani Maumela and Mr. Suleiman Karim, or one of them, which is part of the documents currently being collated by his legal representatives, which we have established is the SIU document and is available. The Chair ruled that it be made available to evidence leaders. I understood that there might be some challenges. I was hoping to have a quick chat with Ms. Missy before I address you to find out if there are challenges in regard to providing the evidence leaders with that document.
Chairperson, I did indicate I do have the document. It's in my file. Had you requested it before I'd run out, Ms. Mhlaba, I would have given it to you. But now that we're here, is it okay for us to give it to you once we've stopped, or do you need it right now?
I would prefer, before we rise today, that we have copies in preparation for tomorrow.
Okay.
Okay, thank you.
Thank you.
Then continuing, Mr. Matlala, we're still looking at the instances you met with General Sibia. Do you know what investigations, if any, he did in regard to Mr. Bushoka's kidnapping? And my second question is whether he reported back to you about that.
No, he never reported back to me.
Never reported back?
Yes.
Did you have any dealings with General Sibia after that engagement regarding Mr. Bushoka's kidnapping? If so, can you just quickly articulate the nature of the dealings?
Dealings meaning?
Any engagements with him, further discussions?
I think the engagements that I spoke about is the one that I said I cannot go into the details of that engagement.
Now, you cannot, okay. You cannot go into the detail as regards those engagements, and please say it again, because, what is your reason again? Which right are you asserting this time?
It's both because I've been questioned about him, and there's a statement that is made, the 204 statement, and also is because there's an investigation that is currently ongoing.
Okay. Then let's take it one at a time. The Section 204 statement is made by who?
By myself.
In which matter? Or regarding which investigation?
The Medicare matter.
Medicare matter.
Yes.
And I take it that a Section 204 statement is one that would effectively render you a state witness.
No, I'm not a state witness.
Okay, so what Section 204 statement are you talking about? Unless I've got my CPA all mixed up.
I do not know how, sorry?
Yes, I think Advocate Missy might help.
Chairperson, if I may interject at this point. Chairperson, you'd have noted earlier on we made reference to the fact that some of the claims to privileges that he wants to lay are in relation to the questions that were asked to him during the interview for this and may be found in the Section 204 affidavit, which is a privileged document, and which is why we were of the view that the attorney on record would be another individual who is also an officer of the court who can confirm that he really is a suspect with regards to these interactions with said individuals, and therefore would be in a position to claim privilege. And so, which is the reason why Mr. Madlanga keeps making the submission that I cannot speak to this here because I'm being investigated. I've addressed it in Section 204, and you would note that when you are being investigated as a suspect, as far as I understand, it's not specified to you that your charge is A, B, C, D, E, F, G. And therefore, it makes it even harder for him to pinpoint exactly why said information was required for me to give to the individuals during my Section 204. And therefore, I need to claim privilege over this particular point. Chairperson.
Oh, Ms. Zildo will respond, but may I say this so long? My understanding of how Section 204 works is that somebody who may be charged of an offense or who has even already been charged of an offense may then be engaged by the prosecution to be used as a state witness. And then in terms of Section 204, that person may then be discharged in the sense that they will no longer be charged with that offense. But if they answer all questions truthfully and satisfactorily, and they are even called a Section 204 witness. So just before your, or what you called an interjection, Ms. Sillo wanted to understand if by his repeated references to his Section 204 statement, he is suggesting that he was or was to be a Section 204 witness. Yes, Ms. Sillo.
Indeed, Chair, that is what I'm trying to understand, because if it is in respect of Medicare 24, what we know right now is Mr. Madlanga is an accused person. If he has signed a 204 affidavit, which as the Chair points out, he could be discharged from the charges that he's currently facing, and I need to test whether or not he's an accused or he has become a state witness in the Medicare matter, which, as I understand it, is the matter in which he deposed to a Section 204 affidavit.
Or if none of those, how then does a Section 204 statement feature?
Chairperson, my apologies. So the plea agreement fell through at that point, so it didn't become a Section 204, to my understanding. And so with that being said, that information then made him understand that with regards to point A, B, and C, D, I'm a suspect and I'm being investigated. And that's how he then we have come to the conclusion that he may be in a position to claim his right to privilege.
How do we, without sight of the 204, how do we as commissioners determine whether the reliance on Section 204 is properly raised? And that properly as in is, it's validly raised and it should be upheld.
Chairperson, in that instance, we tried to aid the situation or the dilemma that we also had come to, as per your question. And the only solution that we could come to is that the attorney, being an officer of the court, would be in a position to confirm that indeed, to the extent of ABCD, having read this affidavit, we can confirm. And I believe from that point, then it would put the commission in a better position to say, well, Mr. Madlanga and through his legal team are actually correct when it comes to ABCD. But as it stands right now, it would be impossible for him to engage you with regards to those points. And again, as we had apologized with regards to not being able to deliver the replying affidavit timeously for the commission to have sight of it, because that's the main reason why we needed the instructing attorney to both have a look at the docket and the Section 204 and give the commission an insight into it.
If I may, I think there is a third option that perhaps Advocate Miss is not alive to, which is providing this commission with that Section 204 affidavit, even if it's on a confidential basis, for the commissioners and the evidence leaders to consider the contents thereof, to appreciate the rights that Mr. Matlala seeks to assert at every turn as a result of that Section 204 affidavit having been deposed to.
If I may just add to that, because I was going to say something along those lines, that if his attorney, and underline this which you said, is an officer of the court, and therefore we must take his word for it, why does that not apply to the evidence leaders who are also officers of the court and officers of the commission and the commissioners as well, as a quasi-judicial body made up of lawyers? Why does that not apply to them? And that's aside from the question of, surely you couldn't be saying that the word of the attorney must be taken to be the word of Mr. Matlala, and if the attorney says, that's what that affidavit says, we must blind to the document, and without it coming from Mr. Matlala's mouth, we must accept that what the attorney says, we have to make a decision on that basis. On what authority, on something so important and with far-reaching consequences, on what authority would you say we must proceed in that way? Because it's not just a matter of preference. You obviously prefer that. So put preference aside. It doesn't work on preference. It works on what is the authority for denying the commission the access to that Section 204 affidavit, especially where Mr. Matlala has repeatedly invoked it and offered, he's referred to it. It doesn't come out of a vacuum. We are having this conversation because the witness in the box keeps saying, it's in that affidavit. Why are we not entitled to look at it? And the answer to the why must be, on this authority, you are not allowed to look at that Section 204 affidavit.
Chairperson, if I might be given a moment to just confirm with my learned friends. Chairperson, if I may. Commissioner, in terms of Section 105.10, when you're no longer a state witness,
Of the Criminal Procedure Act?
Yes, of the Criminal Procedure Act, you are then given a right of privilege over any information that you would have deposed to in the initial affidavit. And the moment you expose that affidavit, any and all issues that are addressed in that affidavit are now in the fray. And you waive your right to not be, you waive your rights that's given to you in terms of section 105.10. Consequence to that, what we consider is that if there's even any other issue that he has addressed in that affidavit that he's given privilege over, even if you hadn't considered it, if we expose it to the commissioners and not through his attorney who has legal privilege, it then implies that you would have seen all the information that he's given protection over, which you wouldn't ordinarily be entitled to, which is protected not to disclose to anybody else, as we have now established that he's not a state witness, Chairperson.
Thank you, Commissioner. Perhaps we might benefit from taking a step back, and I do so by posing a question to Mr. Matlala. Mr. Matlala, you concluded what we call a Section 105 capital A plea and sentence agreement with IDEC, didn't you, in this Medicare matter?
Yes, that's correct.
And that agreement was presented to the court as it ought to be and was considered by the court, and the sentence was rejected by the court, and the court counter-offered with a higher sentence.
That's correct.
Which, in terms of the law, you have a right to consider, accept, or reject, and you elected to reject it on the 13th of July 2026 at your appearance in court.
Yes, that's correct.
And you accept that once you rejected it, the entire Section 105A plea and sentence agreement fell by the wayside. It became null and void.
Yes, that's true.
Now, the affidavit that we are discussing now, you deposed to in the process of negotiating that Section 105 capital A plea and sentence agreement. Am I right?
Yes, that's correct.
Now, both of them have since become null and void. Do you accept that?
Yes, I accept that.
Okay, this perhaps now to address myself to Advocate Misi. The subsection 10 of 105 capital A simply says that the trial starts quote unquote de novo, and the contents of those documents are not applicable as against the accused person in that particular trial. That's what the subsection provides. Now, Advocate Misi seems to extend that to suggest that both documents cannot be considered, even if it's not to determine the guilt or otherwise of the witness before us, but because they've become null and void for purposes of that criminal trial, therefore some privilege extends to them. I'm still unclear, Commissioners, what privilege exactly Advocate Misi is extending. Thank you.
If I may, Chairperson, I have here before me the actual provision. And at subsection 10, from letter number B, sub B. No, my apologies, sub A. Unless the accused consents to the recordings of all or certain admissions made by him or her in the agreement or during any proceedings relating thereto, any admission or record shall stand as proof of the admission if it does not fall de novo. So our understanding and interpretation is that the fact that he does not consent to waiving his right with regards to the information that he had given willingly in lieu of the fact that he would stand as a state witness, it then implies that he's covered not to disclose any such information that he had given willingly in lieu of the fact that he would be a state witness. The problem then becomes in the instance where this document is regarded as a privileged document. And by my understanding, and it is our argument and submissions, right, that if we then say outside of his attorney and legal representatives who have privilege over this information, we hand it over to the commission, it then implies that not only are you going to be able to look at those particular statements that you're asking questions about, any and all information that is disclosed in there that you possibly have not even considered asking questions about. It puts us in a position where you have sight of it and you very well might say, well, but we think and we consider this not to be something that's privileged. And so I understand how is it possible that the commission would be able to close its eyes to any other point that's made there and only look at those particular averments that he makes that relates to the questions that you are asking. Because and our understanding is that the moment he says, you very well might look at that affidavit, he loses his privilege not to have that information that is given during those proceedings exposed.
Chair, if I may, and perhaps it's time to turn to Section 105A, the rights that are protected in that section, particularly sub 10, which Advocate Missy refers to, are intended to protect the accused against any prejudice as a result of the agreement concluded or the plea and sentence agreement in that particular trial. That's all. Advocate Missy suggests that the privilege extends to the world at large, whereas the privilege in terms of the section itself protects the accused person again in that particular trial, where he deposed to both the plea and sentence agreement and the Section 204 statement, affidavit. So, Commissioners, I suggest there is no legal basis to refuse to provide both the sentence and plea agreement, which has since become null and void because Mr. Matala rejected it, rejected the proposed sentence on the 13th of July. And it is literally pro non scriptum. It cannot be used against him in that court. Similarly, the Section 204 affidavit that he deposed to. Both documents can never be used against him in the trial that he's currently facing. Section 105, capital A, guarantees him that. So if they are going to argue for non-disclosure, I submit that they have to advance a different legal basis for the non-disclosure, not reliance on Section 105, capital A. This is not a court, a criminal court sitting in the Medicare contract criminal case. Thank you, Commissioners.
Ms. Missy, well, first to make the obvious point, Mr. Matlala is not in a criminal court before us. He's not an accused before us. That's the one point that Ms. Silva is making, and it's my point too. But two, it seems obvious to me that Mr. Matlala can't have his cake and eat it. He can't invoke the Section 204 affidavit when he's required to answer questions. He can't say, it's in the Section 204 affidavit, and so I don't want to deal with it. And then at the same time, say you can't look at the Section 204. Then if that were to hold, and I've said to you on what authority would that ever hold, if that were to hold, it would mean that, in fact, he just needs to assert it. He just needs to say that if I answer that question, or if I speak to that, whatever you're asking me, if I give you an answer, I'm self-incriminating. And if your proposition or submission is correct, it would mean that's the end of that inquiry. It would mean that. And I want to suggest to you that the correct position has to be that what he asserts when he invokes that privilege against self-incrimination, it requires that we must assess and evaluate whether that defense or that protection is being properly invoked. And the only way we can determine that is by looking at what it is that he's refusing to answer. I'm still to hear you say that we are wrong in that position, that in fact his say-so is sufficient. And if you're correct in that proposition, then we could never, ever, ever make any inroad with any witness, because all witnesses can come and sit here and say, well, you know what, there's a recording, and in that recording I say things that are being investigated. That's the end of the matter. Similarly, for Section 204, all he needs to say is there is a 204 affidavit. If I speak to it in any way, then I'm incriminating myself, and that would be the end of the inquiry. We would never have a witness that answers questions. You may, if you have an answer, you may respond to me and to Ms. Silo.
Chairperson, it's not an answer, but my question then would be, are we to say that the rest of the provision that refers to during or any proceeding relating thereto, that in these proceedings in the commission, we are excluding the commission to include any proceedings relating thereto?
What is the relating thereto? What is the thereto that is referred to?
The agreement, to be precise.
These are not proceedings about the agreement. We're not having a trial that relates to anything that affidavit may be covering. We are not having a hearing about that agreement if the thereto is the agreement. We are not doing that. We are engaging, and I want you to remember how we get to this point of discussing the Section 204, is because Mr. Madlanga repeatedly makes reference to the Section 204. He says, I'm not answering that. It is in the 204 and all of that is being investigated, is under investigation. That's how we get there. And for me, the fundamental question is a witness entitled to say that which you're asking me is in a document, but you can't see that document, and that's a complete answer? It cannot be.
Commissioner, we're not saying that it's just in any document. We're saying that it's in a document that is privileged. And in terms of which that agreement, the moment you don't become a state witness, it falls away and nobody has to have sight of it, because it then goes to the fact that he willingly brought himself and has made admissions, all types of admissions, to which, as the commission, because you are investigating some of these occurrences, these events, and perhaps even the evidence that he makes reference to, it then implies that any witness that comes forward and says to the state, I am willing to be a state witness, let's negotiate. If that negotiation falls through, any commission at that point will not respect the fact that your admissions and the privileged document that you had entered into an agreement about is no longer privileged simply because you are called before a commission.
You see, we did not have, I hope you are listening to me. I hope you are listening to me. We did not have to get to this point, and I'm addressing you as well, Mr. Madlanga, on this. We did not have to get to this point about whether or not this Section 204 statement or affidavit or the contents of it should be divulged. Mr. Madlanga could and should actually have responded to the question directly. If Mr. Madlanga said, your question relates to A, B, C, D point, which is about one of the crimes of which I have been charged, therefore I risk incriminating myself, that we would understand. There is no need for him to refer to the Section 204 statement as some umbrella cover for his protection. As I said earlier, there is authority from the Constitutional Court that says you must clearly identify the crime to which you are referring in asserting your privilege. And then that should take you to whether, in the face of that, the question put to you is a question that you should or you should not answer based on whether the privilege under those circumstances can be asserted. You don't have to refer to Section 204 or the statement that you made under Section 204 and to then use that as some overarching protection. Once it's in the statement, therefore, I cannot answer questions relating to it. It should not. I see your junior next to you is shaking her head. Maybe she's going to give you some brilliant point on why I'm talking nonsense. So we do not have to go there. We are not asking for the contents of the Section 204 statement. All that we want is, because Mr. Madlanga is asserting the privilege. Mr. Matlala should say, this is the crime, and this is how your question impeaches on my privilege. That has nothing to do, and it should not have anything to do with reference to the Section 204 statement. It does not have to. And I repeat what I said right at the beginning, which is that without this umbrella cover all that Mr. Matlala uses, we should not have been in this position whatsoever. So much that I will perhaps, I'll let you respond, depending on your response after the advice from your junior. I will then ask Ms. Silo to repeat her question. And I hope Mr. Matlala has heard me when I say we do not have to just broadly and in general terms refer to a Section 204 statement and then say every and anything that relates to the questions you are asking me is contained in that Section 204. That's not the test. The test is there a crime? What is that crime? How does the question being put to you relate to that crime? And are you therefore entitled to assert the privilege? The test is not, this has somehow been touched on in my Section 204 state. That's not the test. That's simply not the test. Yes.
Chairperson, if I might just get a moment to just confer, because I can hear as well that my junior does have a few points that she perhaps wants to relate to me that I missed. Thank you.
Should we take an adjournment and you'll then indicate when we should come back? No, please feel comfortable. Don't rush yourself because you want to make sure that you will convey what's being said to you. But of course, we had indicated that we would be taking the adjournment at 5. Let's adjourn rather than us just sitting and watching. You'll indicate when you are ready.
Thank you, Chair. Yes.
Come here.
I know this is not another forum, but all stand. All rise. Okay, let's resume. Please switch off your phones. Thank you.
Yes, Ms. Missy.
Thank you, Chairperson. We've deliberated about it, and I believe we had idem with the last submission that you've made that relates to him having to specify what it is, what the charge is in particular. And therefore, we should allow Ms. Sello to proceed and ask him the question and allow him to address it as per.
Yes, yes, and I want you to, even if overnight now, but I'm sure your junior can assist even as we are sitting here. I want to have a look at paragraph 109 of, I think it was the first of the two judgments you referred to, Ms. Hassim. Yeah, let me.
Yes, Chair, it's the Secretary of Judicial Commission and Zuma.
Yes.
And it's a judgment of Justice Jafta, which was, it's just me, because there are a few judgments in that case. It's the one that was decided on 28 January 2021. And the operative paragraph for our proceedings is paragraph 109 on page.
The neutral citation is square bracket 2021, close square bracket ZACC2. That's the neutral citation. Please look at paragraph 109 and you'll get the point I was making, and I hope your junior will now understand and not shake her head. Thank you very much.
Thank you, Chairperson.
Thank you, Chair. While on that point, perhaps it is necessary that we play a clip. This is an interview of Mr. Khanyago, the spokesperson of the NPA. And in the course of that interview, he commented about the legal status of the two documents that we are currently debating. With your leave, Chair. Mr. Matlala, if you could listen carefully to Mr. Khanyago's comments there.
The plea agreement is null and void, and we have to accept what the court has indicated. Obviously, it was not within our control as we had agreed, and when there was a change of sentence, and they had the right, obviously, in terms of the law, to either agree or not agree, which they did not do.
This essentially means, Mr. Khanyago, that you have to go back to the drawing board. Anything that was reached in that plea agreement, including what we understood from this court, was an affidavit which contained the names of very senior police officers who are alleged to have also been involved in this rogue tender. You cannot use that anymore. You go back to the drawing board. He then also has to join the other accused now who have been appearing in this matter. Clarification there.
Thank you very much. Yeah, definitely, because now the plea has been deemed to be null and void. Nothing that was in that plea can be used. Therefore, we've got to continue our own investigations from IDEC side. And then, obviously, the matter will come back here on the 11th of September. And what will then happen is we'll then ask for the court to then rejoin him as accused number one in the other case so that he can now be tried. Because by not accepting the plea, he's basically saying, I will want to go full force with the trial. Therefore, that's what is going to happen.
Thank you, Chair. Mr. Matala, I hope you heard that. That is Mr. Khanyago, the spokesperson of the NPA, expressing the legal position as a consequence of your rejecting the sentence proposed by the court in the plea and sentence agreement. And the point he makes, which is what we've been trying to persuade you of, is both that plea and sentence agreement as well as the affidavit you deposed to in the process of negotiation of that agreement, which you refer to as the Section 204, affidavit have become null and void. so they will not be used in that trial. They cannot prejudice you in that trial. And as the chair, I think, pointed out, or Commissioner Baloyi, we are not part, this commission is not part of that trial. On that basis, Chair, I would seek to refer Advocate Missy in particular to Regulation 10, sub 6, which provides that for the purposes of conducting an investigation, the chairperson may direct any person to submit an affidavit or affirm declaration or to appear before the commission to give evidence or to produce any document in his or her possession or under his or her control which has a bearing on the matter being investigated, and such person may be examined by the chairperson or an evidence leader. That's Regulation 10, sub 6. I'll take it further and reference the rules, which at Rule 10 call for documents. At 10.3, the rule provides that should a person claim that a document referred to in the summons, which is the document required, is subject to legal professional privilege, they must, 1, identify the document in respect of which privilege is claimed, and 2, explain the basis for the claim of privilege in relation to each document. The remainder of that rule then deals with the questions of confidentiality and, of course, confirm the chairperson's discretion to determine that certain portions of such document or the document in its entirety is subject to a claim of confidentiality, which claim will be upheld by the chairperson. That's at the chairperson's discretion. Based, therefore, Chair, on Regulation 10.6, we would request that the Commissioner's rule, the Chair rule, that Mr. Matala, and by extension, of course, his legal team, make available to the evidence leaders and the Commission, purely because Mr. Matala, at every turn and in response to every question, invokes the Section 204 statement or affidavit to make available both those documents for consideration by this Commission to determine the extent to which the contents thereof are relevant to the matters before the Commission. Thank you, Chair.
Ms. Sidlo, I'm loath to make such a ruling without full written argument on the point. I'm not sitting here. I'm not altogether sure how Section 105A 10A should be interpreted for purposes of whether this commission can, regardless of the nullity, have access to and use the affidavit that was produced in the context of the plea bargain proceedings. Sitting here now, I'm loath to right away make that kind of ruling. I would have to be addressed fully and with written submissions on the point. I was making a slightly different point when I engaged Ms. Missy right at the end before the adjournment. I was saying we got to the point that raised the question of whether this commission should have access to that 204 statement. We got to that because Mr. Matlala chose blanketly to rely on that statement to assert the privilege. And the point I was making was the proper approach for Mr. Matlala is, in accordance with paragraph 109 of the Constitutional Court judgment, to refer to a specific crime, the paragraph says so, and say because of that specific crime, this is how that question impinges on my privilege, and therefore I assert the privilege. For that purpose, he ought not to rely on the fact that he has made a 204 statement, because that doesn't specify the crime on the basis of which he is asserting the privilege. So that's why I said we ought not and we should not have reached the stage which we reached. We reached it because of the blanket manner in which Mr. Madlanga kept referring to the 204 statement. We should not get there. I would suggest that between now and the time that we adjourn, you put your questions again. And Mr. Madlanga, I repeat, and this was the purpose of the adjournment, I repeat that I will not accept blanket references to your 204 statement, because the 204 statement is not in and of itself a specified or specific crime, a specific crime for purposes of the judgment that I have referred to, and which is authority on how and under what circumstances you can assert the privilege. So do not again blanketly refer us to your 204 statement. Tell us the crime and then claim your privilege. So for now, let's just proceed with your questions on the basis that I will hear nothing of this blanket reliance on the Section 204 statement. And if you insist that we should have sight of that statement or affidavit, I will insist on being furnished with written submissions by both sides on that issue, Mr. Sillo.
I accept that, Chair, if I may, with your leave extended. Much as you say, Mr. Madlanga, in refusing to answer a specific question posed to him, must specify the offense, which is what section, paragraph 109 of the Zuma judgment tells us. Equally so, the point I sought to make and the purpose for which we played that clip is that very document is null and void in the very criminal trial that he is currently facing. So he can't invoke it for purposes of a fear that it will prejudice him in those proceedings. So he can raise that as well.
Yeah. I hear you.
Thank you, Chair.
I think that's a valid point. Yeah,
thank you.
I hear you. Thank you.
So then, Mr. Madlanga.
I hope because when we took the break, Ms. Missy, that was the point on which I was engaging you. That is, I will have none of this blanket reliance on the Section 204 statement. That's when you and your junior engaged each other, and when I said, let's rather take an adjournment rather than watch you engaging with each other. So I hope you did engage Mr. Madlanga on the point, which is the point I raised with you specifically. And that Mr. Madlanga now understands that he cannot in a blanket fashion just say, because this was in my statement. But in any event, Ms. Sillo makes a valid point, which is that the fact that it's in that statement can't be used against him in the criminal proceedings anyway. I'm just expressing a hope that this was discussed fully. I hope I'm not inviting a debate.
No, Chairperson, you're not inviting a debate. I can confirm that we did impress on him and explain to him why you're taking issue with it with regards to the blanket statement. And so I do hope that moving forward, he'll be able to answer you as per that issue.
Thank you. And Mr. Madlanga, the point I'm making applies across the board, actually. It's not just about the Section 204 statement. It applies to any and every issue that may arise upon, or rather, based on the questions that you are going to face from Ms. Sillo. So you cannot, in very broad and generalized terms, say that's going to incriminate you. We should know what the crime is, and then based on that and looking at the question, see whether indeed you're asserting the privilege is warranted under those circumstances.
Thank you, Chair.
Yes, Ms. Silva.
I take it, Mr. Madlanga. Did you want to say something, Mr. Madlanga? You looked at the chair like...
Yes. If you want to respond, you may, Mr. Madlanga.
No, I actually acknowledge what you were saying. There's nothing more.
Okay. Then how we got here, Mr. Madlanga, was we were engaged on your third, fourth, whatever, incident where you met with General Sibia and you said that he had invited you to discuss the kidnapping of Mr. Bushoha. You then suggested that you cannot go in any further detail as to that engagement, and for that purpose you relied on Section 204 statement. So now it says you can't, not in the manner that you choose to, because in any event that statement itself has become null and void. So then I repose my question. Can you briefly state to the commissioners the nature of the engagement you had with Advocate Sibia, General Sibia, about the kidnapping of Mr. Bushoha? My apologies, General Sibia.
I think on that issue, I already said that he asked me what do I know about it, or you want me to explain what did I say to, after he asked me what did I know about this kidnapping, do you want me to explain what did I say to him?
Yes.
Okay. Yes, he started by asking me that why are they accusing me actually of that crime? And I took him back and I explained to him that as soon as Jerry's was kidnapped, I suspected two things. The first one was I went to Jerry's house together with Jerry's brother, and then Jerry's brother said to me, I must ask Jerry's wife to give me Jerry's cell phone, because should she find out that there is Jerry's side chick's number in that phone, she will go crazy. And then she said I must lie to her and say this phone is going for investigation. And I did that. That's the first point. So the second one is I told Jerry's wife and Jerry's brother that why don't we tell the police exactly what was Jerry doing, so that at least when they looking for him, they will know which direction to look for. And then I think those two things might have triggered what Jerry's wife did to end up saying I kept Jerry at my house, which is not true anyway. So, but those are the things that I discussed with General Sibia.
And are you able to say what was the outcome of that engagement? Because it's not clear whether he was talking to you or with you in his capacity as an investigator, having taken over the investigation, or purely as a senior police officer where others are investigating that kidnapping.
What he said to me is, he said to me that if he can crack that case, it will help him a lot. So I will assume that he was doing that as a police officer, obviously, because he wanted to be the one maybe to crack that case. Then he wanted to know what do I know about it, since Jerry was my friend.
And I think earlier I asked whether after that engagement you had any further interaction with him about this matter.
The kidnapping matter?
Yes.
No, he never, it was only that time.
Okay. Now, you recall that we were dealing with these issues because paragraph 2.2.3 and 2.2.4 had inquired of you the nature, extent, and frequency of communications and physical meetings with General Sibia. We had said this perhaps is about your third encounter with him. When next did you meet with him, and for what purpose?
The other encounter, I said, is the one that I do not want to talk about it because I'm being charged with corruption. I'm not talking about 204. I'm being charged with corruption, and then they also investigating him on that matter. So,
please say the last bit again, and also?
The investigators, they are also investigating him. Firstly, I'm describing the crime. So yes. I said I'm being charged with corruption.
Is this in the Pretoria case?
The Medicare, yes.
The Medicare case?
Yes.
Oh, this is corruption in the Medicare contract.
Yes.
Is it part of the ongoing criminal case, or would that be an extra charge?
Ongoing criminal case.
So you then, this corruption that you fear you may face a charge for arises from your physical meetings and gatherings and communication with General Sibia.
That is correct.
And would both of you be charged with corruption, or just you?
I'm already charged, so I'm saying I do not want to say things that
Okay.
will end up making my trial difficult for me. Well, basically, what I'm saying is it will infringe my fair trial rights.
Okay. So that will infringe your rights in the ongoing corruption charge in what we call the Medicare,
Yes.
because corruption is one of the offenses you
Yes.
are charged with.
Is this the IDEC investigation?
Yes, that's correct.
And this would relate to your interaction with General Sibia. You may disclose something, you say, that would compromise your defense against the corruption charge if you were to speak about this fourth interaction with General Sibia.
That's correct.
Okay. And thereafter, any other?
There's two occasions, but both is the same corruption charge, yes. I'm not mentioning when I went to see him in this office for the Jerebo Shoha issue and also for the public works hospital lease.
So, if I understand you correctly, after your engagement regarding the kidnapping of Mr. Bushoka, you met with General Sibia 3 more times.
Commissioner, I'm just saying, on top, I cannot guarantee that it's 2 or 3. I'm just saying from the top of my head, I'm not sure about that.
Oh, and where's my 3? You had said, I said, when was the next time you met? And then you brought up the corruption case in Medicare. And I say, beyond that interaction, any other, you say 2 other occasions. That's how I land on my 3.
No, I said except the 2 other occasions when we met in his office. 3 occasions, actually.
So now you had this interaction that could potentially undermine your defense in the ongoing corruption case. I want us to get past that interaction. I want the next time you met with him.
There is no next time.
Was that the last interaction you had with him?
Yes. The last interaction is, I think, is what is it? That engagement party. I don't think there was after that. I don't recall.
So the next time you met with him thereafter, to your recollection, was perhaps the engagement party you referenced earlier? You have to verbalize your answer.
Yes, I said that, Commissioner.
Don't nod, Mr. Matlala.
I'm sorry.
Thank you.
The recording doesn't see a nod. And since the engagement party and the interaction at the engagement party, have you had any meetings, physical or otherwise, communications with General Sibia?
No, I've never.
When was this engagement party, to your recollection?
Sometime in 2024.
So you said, okay, you can use the season, winter, summer, I'm trying to.
I think it was towards the end of winter, if I'm not wrong.
So I can say mid-year 2024.
July, maybe July, somewhere there.
Did the other witnesses not say it was 14 September?
No, I'm not sure, Commissioner. I'm not saying that. I'm just.
There's confirmation that yes, the other witnesses so said.
He might be right. I'm not.
Okay.
I'm not saying that is the truth.
So then I'll accept that. The last engagement you had with, or interaction you had with him was at the engagement party in 2024, whatever the actual date was.
Not the last, the timelines, I'm a bit confused with them,
Yes.
but it's one of the interactions, yes.
Okay, then let's get past the engagement party. When did you next engage and interact? After, now we have the engagement party in our minds. I trust fund was heard by all, so after that, when did you next engage?
What I can remember is our own,
Sorry to do this.
Yes, Commissioner.
There's confusion about the third and fourth occasion. If the engagement party was in September
Yes.
and the raid was on the 6th of December, then it must mean the engagement party is the third occasion and the raid is the fourth occasion. Because December comes after September.
Indeed. Do you understand?
no, I understand, yes.
Yes. Remember we discussed the
Your
kidnapping of Mr. Boshoka?
Yes, yeah,
And you said it was after the raid.
yes.
So the commissioners point out to us that the order of things is not right. The engagement must have come before your engagement with him regarding Mr. Boshoka. Because that was only after the 6th of December.
Of course, yes, I agree.
So we should swap the dates around.
Of course, yes.
You said yes.
Yes,
Oh, you're still thinking. I don't know.
I'm thinking,
I don't want to rush you.
I'm trying to remember, I think, if I'm not wrong, I also met him in 2025. So I'm trying to remember while you're speaking, I'm sorry. So, I mean, I was trying to get the exact date.
Then perhaps if we say, while we correct that you then met him next in 2025, perhaps if we discuss the circumstances of that meeting and what was discussed, that would help us sort out the order of things, hopefully. So what did you, in 2025 when you met, what was it about and where and how did it come about?
Commissioner, I'm saying I think I met him in 2025. I'm not certain, but judging by the timelines, because after the raid, I remember I didn't have, there was no way after the raid, first I'll say maybe 15 days, there was no way that I could have seen him because I was busy with police and then I was busy with my meeting with, so it must be maybe January, I think.
Oh, okay, I think I get you now.
I'm trying to have a proper recollection, so.
And is that in relation to the discussion around the kidnapping of Mr. Boshoka? That's the one you're putting it around January 2025, am I understanding you correctly?
Yes.
Okay. So then, after the Mr. Boshoka discussion with him, when would then you would have met again?
I don't think I've met him again after.
Since?
Yes.
Have you ever communicated with him directly or via Sergeant Ngosi?
Communication, yeah, I think there was a communication via Sergeant Ngosi, yes.
Are you able to just highlight what the communications was about and who had initiated such communication? And if they are different, then you can enumerate each and talk about who had initiated and what each communication was about.
The communication was through, all the time, was through Sergeant Ngosi.
But at whose instance?
If I remember well, the communication was regarding after the raid, why did I tell the police that I know him? So, I think it should be in December. After the raid, maybe before January, I think there was a communication.
Okay.
I'm just confused. I'm not.
Okay.
I'm sorry. I'm
Okay.
I am not.
Are you now referring, remember there were two raids in December. There was a raid at your house.
Yes.
Where the police were looking for Mr. Boshoka. Then there was a raid at CAT VIP services where there was the issue with the key and the fact that it's not in the right safe and firearms were taken. Which raid are you referring to?
After the first raid, I think 10 days after the first raid, that's when, 10 days after the first raid, that's when I made that High Court agent application. And in that High Court application, that's when I mentioned that I know General Sibia. So that's when I get a message from Sergeant Ngosi that why did I mention that I know him? Because it was in the media, I think. So that's why I'm saying I think in December there was some communication.
So after the 20th of December?
Yes, somewhere there, yes.
Thank you. So do you recall having a discussion with General Sibia about an application that was necessary to launch for the return of the guns and I think jewelry you said had been seized during the raid of your house or office, one of them?
Yes, but that is part of the case that I'm attending in the Johannesburg High Court.
Medicare?
No, not Medicare, the other one. In Johannesburg High Court.
The one concerning the conspiracy to commit murder, attempted murder,
Yes.
and lawful possession of a firearm and ammunition, money laundering.
Yes.
What relevance does General Sibia have?
There is a relevance because I have my defense. I need to establish how did I end up being arrested. So because in my phone records, they are relying that I'm part of me and General Sibia and Minister Mkhunu. We part of people who plan to dismantle this PKTT unit. So that is something that I'm going to argue in trial, that how did I end up getting arrested.
What is the crime in dismantling the PKTT?
The crime?
Well, you said, perhaps I misheard you, my apologies. You said there is an accusation that yourself, General Sibia and Minister Mkhunu are what about the PKTT?
Commissioner, when they did my cell phone downloads, there was communication which I do not want to, because it's part of evidence in my criminal court in the Johannesburg matter. But there is those engagements and where also General Sibia has been involved there.
You said something about the PKTT. Can you say that again?
The dismantle, of the T.
Oh, yeah, okay.
Yes.
So that's why I say, what is the crime in disbanding the PKTT? What's your understanding arising from that case?
Not the crime, not the crime, Commissioner. I'm saying part of my defense. I'm going to establish in court how did I end up getting arrested. The only way for me to explain this to you now, I have to go deep, and which I do not want to do that, and now disclose my defense strategy.
No.
I do not want to do that.
I'm not inviting you to. I was talking about an application you initiated or instituted in December.
Yes.
For the return of your guns and jewelry, which had been seized during one of the raids.
Yes.
And I asked the question whether you had not engaged with General Sibia around that application for the return of your property. So your response then speaks to the criminal case of murder and attempted murder and the disbandment of PKTT. And I'm not sure I understand.
Because your question, what you're asking me now, is also part of evidence. What you just asked me now is part of evidence, which is in my cell phone downloads.
Isn't that perhaps, Mr. Matlala, the best way to proceed is The direct question that is asked is you had such an application before court where you went to court to seek a return of your firearms. That's what Ms. Silo has asked at this point. So it seems to me that your answer would be yes, I did, or no, I did not. And then we pass that and let's hear what is the next question before you get to a point where you say, but that case has to do with the matter that I'm presently facing and the defense. So maybe take it step by step. At this point, all she asks is you had such an application where you went to court, you wanted a return of your guns and jewelry. And answering that question at this point does not require you to get into the detail of that application, and I don't know if she intends to ask you that further question, but at least as a starting point, your answer doesn't require you to speak about what was in that application.
Commissioner, I already conceded that yes, I've made that High Court application, but her next question was, did I ever discuss that with General Sibia? That was her question.
And your answer could be yes or no, and if she says, what did you discuss? It seems to me that at that point, you may well attempt to raise your defense, your privilege.
Commissioner, I don't think this is fair because now I'm disclosing part of my defense strategy now. I don't think that is a fair move. I don't think so.
You are not, at least as I understand, you are not saying, I don't want to answer that question because it will incriminate me. You are saying, I don't want to answer the question because I don't want to disclose my defense strategy.
Yeah, that's correct.
So it's the second one.
Yes, that's correct.
And Ms. Silo will decide whether that's good enough for purposes of further discussion.
Well, I would think that, and perhaps it's a tad unfair to Mr. Matlala, because the answer really lies in Section 3, Sub 4 of the Act, which means he must invoke some legal privilege. And in regulation, I think 610, it tells you that the only basis to refuse to answer a question is if you establish a privilege contemplated in Section 3.4, which is a privilege as recognized in law, and fear to disclose your defense as not one such privilege. So if that is the only basis, then you do not bring yourself within the ambit of the protection, because that does not constitute privilege, and you will be compelled to answer. You are raising a wrong basis to refuse to answer. It's not an acceptable basis, as determined by the law, not by us around here.
Maybe, Commissioner, it's because you are speaking to, I'm just a mere layman. I do not understand the law, and then I do not know which case law I should invoke in these things. I think maybe my legal counsel will help me with that. I do not know how to invoke which section for that.
I think that's fair. That's fair. So maybe to address myself to the commissioners and ask the commissioners to inquire from Advocate Misi whether she would like to engage with that point on your behalf.
Thank you.
Thank you.
Ms. Missy,
Should I answer?
What are your
May I answer
submissions,
rather?
your submissions in response?
Yes, Chairperson.
Does the privilege extend to not, or rather, a witness saying, I will not answer because I do not want to divulge or reveal my defense strategy?
Chairperson, at some point we raised the question as to what exactly is this charge that you are facing that speaks to that particular piece of evidence and defense that you would not like to disclose before the commission. One, because we were only briefed with regards to the proceedings before the commission, we're not fully aware as to what are the charges that he faces in that matter that speak particularly to that piece of evidence for us to then say to Mr. Matlala, we do understand you, and from this perspective here, you would be able to claim your right to the privilege in terms of Section 3.4. And so, Chairperson, the only thing that I could do at this moment is if the Commission could allow us a stand now so that we can consult with regards to this issue, bearing in mind that we're also in a back footing with regards to the charges that relate to that case before the Johannesburg High Court, I believe.
Just repeat the underlying facts that give rise to this issue, so that when instructions are taken, they are taken in the context of the point from which you moved to,
Yes.
for us to get to where we are now.
The chair will recall that Mr. Matala and I were recounting the incidents he met with General Sibiya and they discussed, and the idea was to understand the content of such discussions on each incident. And I had posed a question to him whether he had met with General Sibiya regarding an application he instituted for the return of his firearms and jewelry, which he stated at the time had been seized during one of the seizure, one of the raid incidents, either at the home or subsequently at his office. And he confirms, yes, he did institute those proceedings. So the question was whether or not he met with General Sibiya and discussed that with him, to which then he claimed he invokes a privilege, not in the Medicare matter that we've been dealing with, but the other matter in Pretoria, I think, about conspiracy to commit murder, attempted murder, unlawful possession of a firearm and ammunition, as well as money laundering. So it is in the context of understanding the charges that he's facing there, I'm trying to appreciate what his engagements with General Sibiya regarding, I would term it the lawful return of his property, what bearing it would have on that case. And that's where I think we fail to find one, or I fail to understand. Let me lay it on my doorstep.
Thank you. Yeah, maybe for a fuller background, during the raids, some of Mr. Matlala's company's properties, and indeed even his personal items were allegedly, with regard to the personal, and I think it's common cause with regard to the property belonging to the company, were taken by the police during the raid. And the alleged relates to, I think, Mr. Matlala, in a court application in which he was seeking a mandamus, in terms of which he said his, amongst others, his Rolex watch, or was it a Cartier? Yeah, Cartier and Rolex watches, and maybe some other personal item had been taken by the police. So in terms of the mandamus, he wanted the court to direct that those items be returned. But if my memory is correct, I think in the end he either withdrew or did not pursue those applications any further. So that's the full context. And so Ms. Sillo is engaging Mr. Matlala on that. Sitting here, I have no idea how that has anything to do with Mr. Matlala's defense strategy. But in any event, there's the point that Ms. Sillo makes, which is what's Mr. Matlala's defense strategy got to do with the privilege he is claiming, which is the privilege against self-incrimination. So that's the full context. Would you still say you want to take instructions, or would you accept that there is no basis for asserting the privilege in this context? Or perhaps it's not even the privilege, it's something, some other animal, an animal that I will not answer the question because it discloses my defense strategy. But in any event, I just do not see how an application for the return of Mr. Matlala's personal items, I do not see how that relates to any possible defense to whatever charge he is facing in this regard. But in any event, there's the antecedent question. Can he refuse to answer the question on that basis in any event?
Chairperson, while Mr. Matlala was giving his submissions, there was a point at which it seems to me that he makes reference to the issue of a charge and or within the case that he's referring to. And I'm wondering to myself, without having full knowledge, is there a misunderstanding on his part that we would need to consult with him about so that we're able to correct him and give legal advice as to whether he's approaching it incorrectly? This is the manner in which you would have to make the application or claim the right to privilege. Because I do specifically recall him making reference to a charge that relates to the matter. And that's why I'm saying I don't know what the charges are. I don't know how it relates to this particular piece of evidence that, or rather the issue with regards to the application not proceeding, how those two interlink, because now suddenly, or rather later on, he makes reference to it being part of his defense strategy. And as he noted, because he's a lay person, he perhaps might not be viewing this correctly, but he actually knows what he's trying to say.
Is that a point he can raise as a matter of law anyway? That is, I will not answer that question because it discloses, or rather my response will disclose my defense strategy. Is that a legal basis for refusing to answer a question?
Chairperson, now that we have taken the instruction and we've decided to proceed based on where we are, having not heard the application or proceeded with the application at the point, I believe during our consultations, and as part of the application, it called into question as to whether as a suspect or as an accused, does he have a right in terms of Section 35, and would go towards the issue of a fair trial, which there's a confusion with regards to that. I'm just off the top of my head on his part. And that's why I deem it important before we proceed for him to answer it, can we get an opportunity to understand exactly what is this point that he's raising that has to do with the charge and the evidence, as well as the defense that he wants to raise in the trial, Chairperson. I do believe, as he noted, that he's a lay person and lacks a proper understanding how. It's also to avoid an instance where, again, it's just regarded as a blanket approach of, because I am going to use this as a defense in my trial, therefore I don't want to address it. I do believe it's important that we get the opportunity to get an understanding exactly from why is he referring to this, why did he mention the issue of a charge, how does this all interlink, and then we can give him proper advice that in terms of claiming privilege, you have to make reference to the specific charge, etc., before you...
I have bent over backwards and allowed you an adjournment each time you ask for one, but we will never finish Mr. Matlala's testimony if at every turn we have to do this. We have to adjourn for you to take instructions. And I thought this is just a legal question. And sitting here, I just do not see the connection whatsoever with regard to an application, a civil application for the return of Mr. Matlala's goods, an application which he did not pursue. He either withdrew it or did not pursue it to finality, so it died a natural death. I just do not see sitting here, unless we get clarity, I just do not see how that has anything to do with his defense. But as I said, the antecedent question is, can that even be raised as a basis for not answering the question?
My question to that would be no, given where we are in terms of the proceedings. However, I still stand by the fact that he very well, just on that particular point that he tried to explain or go further on with regards to the charges, he very well would be able to explain to us at least so that we can give him proper legal advice as to whether he can claim a right based on that or not. Because Chairperson, like he said, he's a lay person. He's probably trying to approach it from this angle, but in reality, this is exactly what he's meant to be claiming based on ABCD. I don't know what the facts are as much as I also don't know what the charge is that he was trying to make reference to. I think I'm grappling with the fact that he did try and address the issue that has to do with charges and it relates to the defense that he wants to raise. I also don't understand to what extent it would affect his ability to raise the privilege to not self-incriminate. However, I do agree with you that he can't raise the issue of fair trial, i.e. with regards to disclosing his defense, Chairperson. And that's the reason why I've asked for a stand down so that we can at least give him that legal advice so that he understands where we are right now.
Yeah, you see, the difficulty with that approach is that it would be a matter of relative ease for every and any witness to say, I will not answer that question because it discloses my defense strategy. In circumstances where, when you look at the facts, it does not immediately spring out, or the circumstances do not spring out and tell you in and of themselves that this has something to do with a possible defense. Civil case, civil application, withdrawn, and apparently, at least from the evidence that we have had, on the basis that no Cartier or Rolex watches had actually been taken from Mr. Matlala, how that should then lead to the disclosure of his defense in the criminal case, for the life of me, that escapes me altogether. So the short point I'm making is it would be a matter of relative ease for anybody to say, I will not talk about that. That discloses my defense. And if there is no cogent explanation, we cannot accept that. We simply cannot accept that.
Sorry, Chairperson. I think maybe I can assist if you allow me.
Yes, please.
Because I have to agree with you. You are right with one thing when you say you don't understand how this civil matter has to do with my criminal matter. Even myself, I didn't see the necessity of why the state will bring that up. But as you're saying, anybody can come up here and say this will infringe my fair trial rights. So I think what is best that I can do to prove that this thing is part of my trial and then is part of the case that the prosecutor has been relying on. Maybe if I can bring maybe a copy that is signed by the investigating officer to show that indeed this is part of my case. Tomorrow morning, I have that document on me. I can bring it tomorrow morning.
I see that it's 2 minutes to 6. Perhaps we should adjourn at this stage, and then that should afford you sufficient time, Ms. Missy. And yeah.
Chairperson, Before we do adjourn, I would like to understand the position with regards to the suggestion that Mr. Matlala has made, which is to provide...
Can you please
My
pull the mic or
apologies.
speak?
Yes, I would like to understand the position with regards to the suggestion that has been made by Mr. Matlala, which is that perhaps he ought to provide us with a copy, because as I stated, I haven't seen it as well. I don't know what these charges are. And so it's so difficult for me to answer you and address you with regards to that. And maybe he does have a good point to make there. So what is the position to that?
No, that's acceptable. That's acceptable. Yes, you may bring the document you want to bring, Mr. Matlala.
Thank you, Chairperson.
Yes.
And Chair, before we adjourn, perhaps then to facilitate our engagement, it might assist if we were provided with both the charge sheets and you call it the Pretoria matter, the attempted murder case, and the Medicare. I'm not asking for your dockets, I'm asking just for the charge sheet, because that would give us a sense of what the offenses Mr. Matlala is charged with.
I think I have my charge sheets. The charge sheets, I don't know, I will ask. It's fine, we'll make a plan.
Thank you.
Chairperson, because if I may, I believe Mr. Maluleke is the attorney on record in those matters.
Of course, yes, yeah.
And he's still on record here. Surely that would be relatively easy for us to provide same.
Thank you.
Thank you.
Let's adjourn and resume at 9:30 tomorrow.
Yes,